Yes, thank you. Good morning again. Advocate Chauke.
Good morning, Chair.
Good morning. You continue to be under oath.
Thank you, I confirm.
Thank you. You may proceed, Advocate Chauke.
Yes, thank you, Madam Chair. The analysis of the terms of reference relating to Ketomano. We had also done the list of documents that you read and considered at the time. But there is one more that is outstanding. It's the Chauke report, which is referred to, if you remember this document that lists what you considered at page 5 thereof. And SB3, the Chauke report, is the last of those items, correct?
Yes.
Yes. Now, I don't know if you have it easy to get the Chauke report in front of you. It says here SB3, so that should be one of the annexures to the statement by Advocate Batoi.
I've got the copy of the report, although it's not on SB3, but I've got.
No, that's fine. I think there are various versions flying around, so any version will do. So what page is that you're looking at?
It's 053.
Or is that one of the annexures to Advocate Batoi's
Yes.
statement? All right,
Yes.
thank you. Let's just wait for the panel to get their own copies. Well, mine is not numbered. What page is this that you are reading from?
It's SB3.
134.
134, but
Yes.
on the attached it says 053.
No, I
On
think
the
I think the panel is using SB3 134.
That's fine.
You may proceed, Councillor.
Thank you,
They're
Madam
getting my
Chair.
bundle.
Yes, thank you. Now, I can't remember whether that one, if you look at the end, is that the one signed at page 96 of the document? Is that the one signed by Advocate Chauke alone, or the one signed by Advocate Chauke and Advocate Mamabolo?
The one that I have got is the one that is signed by Advocate Chauke alone.
Yes, all right. The one I have is signed by Advocate Chauke and Advocate Mamabolo. And we've covered this before about the discrepancies in the signature. Yes, but what would this tell you, that you have a report that is drafted by 4 people, signed either by 1 or by 2, and then it's got portions there where it says on behalf of, but one of them is signed nevertheless.
Yeah, well, one can accept that maybe when the final report was drafted, the colleagues were sitting from very far apart and they were not able to sign the report from one place.
Now, I understand that, but they would still be able to sign all of them.
Indeed, they will take the last page and then email it or one or another to append their signatures.
Yes. And the fact that they never actually signed it up until now. I mean, this is a 2019 report.
Obviously, one will need to get an understanding from those who have not signed as to the reasons why they have not
Yes.
They have not signed, but one can only think theories and what have you, other than to get the explanation from them why they have not signed the report.
No, that's fine. If you forget about their reasons for not signing, I'm asking more about the effect of not signing, because the panel cannot work on speculation about why they didn't sign. Advocate Riley is coming to explain why she didn't sign, but her explanation may be irrelevant because the effect of not signing could impact on the legal standing of the document.
I'm with you. I accept that if the document is not signed, you cannot place reliance on it.
Yes. Well, if it's written by 4 people, I mean, wouldn't it need a majority in order to be a report of 4?
Of course.
Yes.
Like I indicated, the initial one was signed by 2. The last one is signed by 1. So either way, even if the one that you have got with you, they're signed by 2, there is a stalemate.
Yes.
This one is even worse. That one that was attached to Advocate Shamila Batoi is the one that was signed only on the 28th of June, 2019, signed by Advocate Chauke alone.
Yes. And then Advocate Batoi has repeatedly referred to this as unanimous.
Indeed, that's how I understood it.
Yes. What does that mean, that unanimous?
It's questionable because the signatures of the other members of the panel are not appearing.
Yes. Did you try to understand this thing? Because these are your colleagues. You could phone them up and say, Mr. Chauke, what's going on? Why have your colleagues not signed? Or Ms. Riley, what's happening?
Now, my interaction with Advocate Chauke was, one, why did you finalize the report and write about me without speaking to me? And then he said, no, it's just unfortunate. He did not think it was necessary to speak to me. And then again I said, well, but why did you not speak at least to the prosecution team, at least to hear their views? And he indicated to me that that is unfortunate, but they had the prosecution's memorandum, so they did not think it's necessary to speak to them. That's how far I could take it. I did not even take up the issues about the others not having signed.
Yes, and the other people there, Mr. Mamabolo I think is deceased.
Mamabolo is deceased.
Yes, and Advocate Chauke himself is deceased.
Indeed, unfortunately, may his soul rest in peace.
Yes, and the only remaining members are the ones who did not sign.
Yes.
Advocate Tenga and Advocate Riley.
Yes, Advocate Riley and Advocate Tenga.
So do you think it might be a good idea, because it's not clear to me why the NPA keeps telling us about Advocate Riley alone and doesn't say anything about Advocate Tenga?
Let me not comment about that, Chair. Advocate Tenga should answer for herself instead of me speaking on her behalf.
Yes, no, but I'm asking a different question. That if you have a scenario like this where there is a glaring problem of a report signed by 1 or by 2, and we don't know which one is the final, which one is not the final, but 2 are deceased, there are 2 remaining, that you would expect that the NPA will invite both of those that are remaining to give clarification to the panel about what actually happened. And the fact that they're calling one and not the other, what does that mean?
There could be some underlying causes as to the reason why Advocate Tenga is being called. Like I'm saying, it's once the report is unanimous, it should be easy to say it's unanimous. If it's not unanimous, that on the appearance of the document that the others have not signed, one would want an explanation as to why the other person has not signed and why he's not being called to confirm whether she agreed with the report or not.
There's also another thing I don't follow with their choice of who must come and speak to this report. Who is the senior between Ms. Tenga and Ms. Riley?
It's Advocate Tenga. She's the DPP in Limpopo. Advocate Riley is a deputy in the Western Cape.
So that's also another thing that I don't understand, why the senior will not be called.
Yeah, well, it's like I said, I don't want to speak about some of the things that might not be conducive in this inquiry. But yeah, it's.
But would it be an option for the panel to invite on its own Advocate Tenga to give her own perspective to
Indeed.
how this report came about?
Indeed. Advocate Tenga will be in a position to explain her views about the report and the process that was followed. If you are not aware, Advocate Tenga is the one who decided not to prosecute Advocate Jiba in respect of the so-called tertiary charges.
Yes.
Yes.
No, we looked at that yesterday.
Yes.
And we found her actual report
Indeed.
dated the, I think, 27th June 2019.
Yes.
All right, thank you very much. That matter will be followed up later, depending on what the NPA decides to do, but it's really the cherry picking that worries me. Now, when you look at this report now as a whole, there's something I also just don't understand. There is a judgment of the full court, which we looked at yesterday, which already answers fully the question whether there was evidence or not in the docket to prosecute Major General Boysen. It is contained in paragraph 60 of the case of GCB versus Jiba. And we went through it painstakingly yesterday.
Yes.
Now, then you have the national director of the NPA, who then asks 4 advocates to essentially redo all of the work that has been done by the High Court.
In order to find a reason to justify the withdrawal of the case against the accused.
Yes, well, yes, that's the ulterior motive. But assuming there is no ulterior motive, I'm just talking purely in terms of the legal hierarchy in this country. What you've got a judgment. It's a full bench judgment. It goes thoroughly into the contents of the docket. Then it comes to the conclusion that there was evidence, and it summarizes that evidence. And then it says, based on this, there is no malafide or irrationality on the part of Advocate Jiba in authorizing the racketeering. The court has made that pronouncement. One would have expected that the NPA, being an organ of state bound by the Constitution, would regard itself as bound by those findings.
Indeed, I accept that. Yes. And it's highly improper that you second-guess the courts by trying to investigate that which they've decided. If you are not able with the findings of the reasoning of the court, the issue is to appeal.
Yes. And the same with the terms of reference we looked at yesterday. The effect of the matter, there's a judgment that says there is evidence and that the prosecution is not malafide. And then you have the NPA, which then goes to the president and then somehow gets the president to agree to set up a panel to investigate what the judges have already found.
Yes, like I indicated yesterday, Chair, to me, that is highly improper because, in essence, the president was misled in that respect.
Yes, well,
yes.
The other thing, when you look at this judgment, this report, there is no reference whatsoever to the findings that we looked at yesterday from the GCB case.
Indeed.
There are many references to the judgment of Judge Govan.
Yes. I saw that. My only view is that Govan judgment, in them having misread it anyway, was able to be used to justify the narrative that there is no evidence at all against the Katomania officers and General Boysen.
And you see, this is a 2019 report. The judgment of Judge Legode is a 2016.
Yeah.
Yes, it's a 2016 judgment.
Yes.
So it was there.
It was there.
And then they, for some reason, elected, well, they won't refer to it.
Which is a worry and a concern that at that high level, such omission could be made about the judgment of the full court that was there.
Yes.
Yes.
Now, you anticipated me, and I was going to ask you the process as well, because there is the problem of their breach of the stare decisis principle. Then there is the problem of their selective references to judgments that suit them, and those that don't suit them are just discarded. And then there is a process problem, which is the people that worked on the case, like yourself and Advocate Mayema, who was here, said we were never consulted. And there's a judgment we looked at with Advocate Mayema of the Supreme Court of Appeal, which says it is highly irregular for the National Director of Public Prosecutions to withdraw charges, in that case it was charges against President Zuma, without speaking to the prosecution team.
And that is fundamentally wrong, because in this case, as I indicated yesterday, Chair, once the NDPP at that level receives the representation from the accused or another person, the process is to call the prosecution team responsible, take their views, take the views of whoever, and then make a decision. In this instance, as I indicated, I'm not aware of any representations that have been made by General Boysen. And on the record here, since the start of this, I've never seen them. That is the first thing. The second thing is the prosecutors who dealt with this specific matter have not been consulted. Thirdly, me as well, that I'm said to be affected, that I was part of the decision-making program, was not consulted. So is Advocate Chauke. She was also not consulted.
Yes, that's the process.
Are you aware of that Supreme Court of Appeal judgment? Which judgment is that, Councillor?
Madam Chair, I can find it easily. It's somewhere in our...
I think it's the DA versus President Zuma.
Democratic Alliance.
The Democratic Alliance case.
That is all possible, but we have a specific extract
We will locate that citation
of the judgment in our bundle. Now, so we were dealing now with a process that there is a judgment of the SCA that it is highly irregular for the national director, in that case it was Advocate Mshe, to withdraw a charge without speaking to the prosecution team.
Yes.
Yes. Now, then you raise other procedural problems, which is a charge can only be withdrawn upon representations made by an accused.
Yes.
And in this case, there were no representations.
No.
Yes. Now,
unless if I might have misread the record as we have it here in this inquiry, but I've never seen them. In fact, I remember even when Advocate Batoy testified here, she did not make any reference to the representations having been met by General Johan Boysen.
now we went through this issue with Advocate Batoy.
Yes.
You remember how it started? She comes in February 2019, and then early March of 2019, she has a meeting with Mr. Boysen's attorneys and her advocates. And that's where she talks about having to discipline people like Mr. Mayema, and then referring them back to the Northwest.
Chair, it was the very same month when she started in February.
It was towards the end of February.
Yeah,
yes.
It was, I think, the third week of February that she met with the attorneys of Mr. Johan Boysen, and where those remarks were made.
Yes, and then she gets advice from Mr. Hilton Epstein, who explains the strength of the case of this NPA against Major General Boysen.
Indeed.
But thereafter, Mr. Hilton Epstein is then sidelined.
Yes.
And then that is how this report is then brought about.
Yes, but in the scheme of things, if you look at the pattern, that which is unfavorable to the no evidence rule will be suppressed. You can start from where we're referring to the advice of Epstein. You can go to the issue where the prosecutors are saying there is a case. You can go to an issue where it's being indicated that the recommendation of Chauke is contrary to what it's being done. So it's a pattern.
Yes. Now, just on the process issues, we know for a fact, because Advocate Batoyi was here and I confronted him about that there were no representations from Major General Boysen. What had happened is that she met with the attorneys and the advocates of Major General Boysen and then began a scheme to withdraw these charges.
Yes.
When I asked her what was the basis for this decision, she referred to what was out there, including what was being said at the State Capture Commission. Yes. That was the basis on which she began this exercise.
Yes.
It was not triggered by representations.
Yes.
Yes. Now, is that proper?
It's highly improper.
Yes.
And as I said, my view is that the withdrawal or otherwise of these charges that got nothing to do with the rule of law or the interest of justice. There is something underlying that which, unfortunately, one can just suspect that this is the motive, this is the reason. But legally speaking, and in the rule of law and the interest of justice, this is a highly irregular.
Yeah. Mr. Chauke, in paragraph 450, page 126 of the statement, no, not where you are reading, of the statement of Mr. Mayema, is an extract from the case of Zuma versus Democratic Alliance and others, 2018, volume 1, SA 200, paragraph 89, where it is stated, the exclusion of the prosecution team from the process leading up to the decision to prosecute, especially the final deliberations that took place on 1 April 2019, was in itself irrational. The compelling conclusion is that this exclusion was deliberate. There were senior litigators steeped in the case, acquainted with the legal issues, and had a critically important contribution to make regarding the ultimate decision to terminate the prosecution.
That is the judgment I was referring to, because it's compulsory. There's no discretion that the NDPP can just do a review without following that due process which is stipulated in the Act.
Yes, but there is a judgment of the SCA delivered in 2018 that says if you want to terminate the prosecution, you must include the prosecution team. Excluding them is irrational.
Indeed.
Now, we have a withdrawal or a termination happening in 2019. This is now the third time. There appears to be no respect for binding authorities by the former NDPP, Advocate Batoyi.
What I'm saying is it's one thing to pay lip service to the rule of law, and then we act differently. This is the case in this point.
Yes. Now, there is a further problem that I want you to comment on around the circumstances of the production of this report. You established in your evidence yesterday, but even if you didn't, it's common because there's so many witnesses that have testified on this, that Advocate Batoyi was the fourth of NDPPs that dealt with issues of Ketomano, starting from Advocate Jiba, Advocate Ngasana, Advocate Sean Abrahams.
Yes.
Advocate Jiba issued a racketeering authorization. Advocate Ngasana did not reinstate, but at the same time did not withdraw.
Yes.
Yes. And Advocate Sean Abrahams reinstated.
Yes.
And then the very first prosecutor to make this extraordinary claim that there is no evidence was Advocate Batoyi.
Who did not read the dockets
Yes, well, yes, we know that, but I'm talking about the authority. There is a decision that is already existing,
yes.
made by Advocate Sean Abrahams.
Yes.
How does it work in this NPA that somebody just comes in and they say, although it's my decision because of the principle of legal succession, but I'm just going to change it. I won't ask a judge to change it for me, but the racketeering authorization, I'm just going to retract and withdraw them.
My understanding of decision-making, administrative or otherwise, even prosecutorial decision-making, is that you don't do them personally. You do them in terms of the office. And at times you become factors of it, unless if there is a reason for you to reconsider. If it's an administrative decision, as I indicated, that is what it's up. A prosecutorial decision, it's once you receive representations, of course, that you will be entitled to reconsider. That in this instance, that exercise of that jurisdiction to withdraw is not lawful because it was not done within the framework of the law. As I indicated, and this is probably we can also check it out when you discuss about the advice of Advocate Epstein SC. There was a review application, like in the case when it was Advocate Jiba, which was ready to be, that was going to be argued about the issue of the validity of the certificates as issued by Advocate Sean Abrahams.
Yes.
And after relevant to that meeting that we are referring to, Chair, the NDPP instructed the state attorney to withdraw the opposition to that review.
Yes.
Which is concerning.
Now, then there are other, sorry.
Pardon, Counsel, and the matter was never adjudicated.
Not at all, Madam Chair.
Yes.
And in respect of Advocate Batoyi, was it open for her to launch a review application in 2019?
No, because
before she withdrew those charges against General Boysons?
One would have thought that she would have followed either one to review the decision of made by a predecessor on receipt of representations from the accused persons, or if she felt otherwise, she could have subjected that decision from her office as an office to get a declaratory order from the court to set aside that decision for her to reconsider the decision anew without any representation having been received.
None of the two options she considered?
No.
Thank you, Madam Chair. Do you know, then there are also other things I don't follow, just in terms of the content of this report. So if you go to the section headed conclusion, which is page 92 of the report itself.
Counsel, I'm sorry, just hold on that point.
Yes.
Am I correct that as at the time Advocate Batoyi walked away, these issues had not been canvassed with her yet?
No, Madam Chair, they had not.
Thank you.
Yes. Yes. Hopefully, whenever she comes back, we can cover them with her.
If she decides to come
Yes,
back.
if she elects to come back, yes. Now, if I can just ask you to turn to the, I think it's page 92, under the section on conclusions. There's some aspects there I don't fully understand.
I'm there, Chair.
Yes. Now, so of the actual report at the bottom, so it is SB 3225. That's where it starts. So that's where the conclusions start. If you turn the page to the following page 93, so paragraph 233, 234, 235, up to 238, they seem to be neutral statements that don't make any evaluative judgments.
Yes.
And then the first evaluative judgment is at paragraph 239. They say, after a careful evaluation of the evidence contained in the dockets. Now, we went through this. We know that there are at least 12 dockets that they just never made any references to. They claim they looked at them, but they never actually made any analysis of them. And those that they analyzed are done in such a superficial way that it's impossible that they were applying themselves to them. But giving them the benefit of the doubt. And then they say that pleadings in the various applications brought in this matter, we conclude that there was insufficient evidence placed before the acting NDPP Advocate N. Jiba and NDPP Advocate S. Abrahams to justify the authorization to institute a prosecution in terms of Section 21E and 21F of the POCA. Now, Advocate Batoyi says she relied on this report to come to the conclusion that there was no evidence. But the report doesn't say there was no evidence. It simply says that it was insufficient, but it acknowledges that it was there.
Yes.
So where would she have got this idea that there was no evidence?
I think it's a preconceived idea that she always had when she called for this report. Like I said, remember, at the time when this report was written, they are making reference to pleadings. Those are I take it they refer to the review proceedings, which was withdrawn and which has taken a decision to withdraw from her first month when she was in office. That she somehow the meeting that she would have held with the legal representative of Mr. Boysen, she accepted that indeed there was no evidence.
No, but you say she accepted that there was no evidence, but the point is that the report she relies on doesn't say there was no evidence. And now she has managed to get this panel to investigate the question whether there was no evidence or not, and also managed to get the president to sign terms of reference that say there was no evidence. And when you ask her, where did you get this from? She says she got it from this report. You look at the report, it doesn't say that.
Yeah. But it's a misrepresentation in itself that you say you got this from that, when in fact, when you look into that, that information is not there.
And then in paragraph 240, it says, despite the prosecution memoranda and the statements that were placed before the acting NDPP Advocate N. Jiba and the NDPP Advocate S. Abrahams, these were not sufficient to implicate the accused in the alleged racketeering offenses. Now again, you don't get a statement that says there is nothing. You just get a statement that says, well, in our view, we think it's insufficient.
Yes.
Yes. Then they say the obvious credibility challenges that the prosecution would face in respect of the evidence of Colonel Ayer, in our view, would be insurmountable during a criminal trial. Now, I wrapped my head around this to understand why do they say there is a credibility problem with Colonel Ayer, which seems to be the entire basis on which that statement is concluded. The only thing I could find in this report is that Colonel Aya was criticized in his disciplinary hearing by Advocate Nazir Kasim on the basis that he felt that he was important. So you'll find that at paragraph 109. So if you go to of the report. So yes, that you will see at page 35 of the report.
I'm there, Chair.
Now, this is where they talk about credibility. Remember that they've made an extreme statement in 240 that we've got a credibility problem with Aya that will be insurmountable, and therefore there is no sufficient evidence. You then try and find out in the report what is the credibility problem. So you get it at 109. This is what it says. Aya's credibility was questioned and he was discredited by Advocate Kasim SC in the Boysen internal disciplinary hearing. Advocate Nazir Kasim SC, the chairperson of the disciplinary hearing against Boysen, described Colonel Aya, who testified before him, as a dismal witness in material respects, is obsessed by the notion of his own importance, and his entire testimony was permeated by his political acceptability and self-importance. Now, those are the only 3 lines that speak to the issue of the credibility of Colonel Aya. Is that correct?
That's correct.
Now, two of the statements that are referenced in your own document are the statements of Colonel Aya. Just explain to the panel how you, in your own judgment, evaluated them.
The statement of Colonel Aya were corroborating the fact that he was not in command or in charge of the Katomania organized crime unit, yes, which was also confirmed to the extent by General Johan Boysen himself when he responded to the interdict application by Bongani Mkhize, which was also confirmed by the documentary evidence from the police in which General Boysen they were given monetary awards in respect of the activities of Katomania unit.
And Commissioner Brown? And
Commissioner Brown, who was also confirming that General Boysen actually took over the command structure of the Katomania organized crime unit.
Yes. Yeah, but I mean, is it rational then to say, well, we think there is no sufficient evidence because one witness, we have a credibility problem with that?
No. Maybe let me even clear that. When you make a decision to prosecute, whether or not to prosecute, the issue of credibility does not play. The credibility plays when you need to consider the totality of the whole evidence, whether the whole of the evidence that you have is unreliable to the extent that it's not going to be admissible in court. So but the credibility per se is not an overriding principle in making a decision whether or not to prosecute. We always say, as prosecutors, to say, look, the credibility is going to be determined in court. What we have here is a prima facie case that can lead into successful prosecution.
Yes. So, in other words, even in talking, quite apart from the question I'm asking, which is, well, was there a basis to question his credibility based on the 3 lines from Mr. Kasim? And your answer to that is no.
No.
And especially because it was corroborated by other witnesses.
Yes.
Mr. Boysen himself, Commissioner Brown, making it clear that Mr. Aya is not in fact in charge of the unit.
Yes.
But you are saying, and this is a more fundamental point, that the focus on credibility is itself a misdirection.
Indeed.
When you are making a decision to prosecute.
Yes.
So, yes, that. because the prosecution is based on a prima facie case.
Yes.
Yes. Yes. I mean, the idea that you can actually get witnesses that are so exceptionally strong that they don't have an iota of a credibility gap.
Yeah.
It's just a mystery.
Yes, you can get a very strong witness, and then you think it's a very strong evidence, and 2 minutes into cross-examination, that witness falls apart. It's highly probable it has happened in many instances.
But I mean, the point.
Of course, that's why it is a preserve for the trial court.
Indeed.
Yes. I mean, the point you're making about the misdirection, I mean, it's a point I hadn't considered, that's largely because I'm not a criminal lawyer. But it must be obvious to prosecutors. Why did it escape Advocate Batoyi?
I don't think it escaped her. The result that she always wanted to have clouded her in that respect. Yes. That is an obvious thing. It does not need any further than that.
Yes, all right. Thank you. Now, so that was in paragraph 240. Then there is 241. I mean, everyone seems to have been so taken up by this idea of Mr. Danikas. But we've gone through this case now. There are just so many other witnesses other than Mr. Danikas. You know. Then they say, in respect of the potential witness Danikas, at the time the NDPP advocate S. Abrahams issued the authorization, the statements were still unsigned and no certified translation of the Greek statement had to date been filed in the docket. Now, this is also something I don't fully grasp. Yesterday we looked at paragraph 38, 39, and 40 of the judgment by Govan J in the case of Boysen versus NDPP and others, the 2014 judgment, in which the judge says the statements don't need to be sworn. And where the judge says, my only problem is that in your affidavit you've said you've relied on sworn statements, and I can't see the sworn statements. We also know that to have been subsequently corrected by the full bench. But assuming that to have been correct, that the judge says you say you relied on sworn statements, I don't see the sworn statements. And the same judge says later in another portion, actually you don't need sworn statements because in poker you're entitled to sign a racketeering certificate without a sworn statement. How does that square up now with what they're saying in paragraph 241?
No, it does not square up at all. Worse still, when this report was written and it was considered, that statement was signed. So
I see.
What I'm saying is, at the time when the court panel sat and wrote and considered this matter, and that statement which they alleged that was not signed, it was actually signed.
Yes, because
if indeed they have considered the dockets and everybody is there. It's obvious.
I think they knew that it had been signed because there's somewhere where they say that it had not been signed in February 2016 when Advocate Abrahams issued the second authorization.
Yes.
It was later signed. But your point is that why does that matter? Because in 2019, there was a signed statement.
Indeed.
Yes. Yes, so in other words, if they were saying there is a gap because the statement is unsigned before Mr. Abrahams, there was no gap before Ms. Batoyi?
No. No.
But then what is the problem with an unsigned statement?
As it is, and in racketeering prosecutions, whether the statement is signed or not, it's immaterial. That statement is the decision maker who has to issue a racketeering certificate can rely on that certificate. What happens in the trial about that statement is something completely different.
Yes, thank you. Now, Then it says the prosecution would furthermore have challenges in presenting this evidence as similar fact evidence for the reasons as discussed in this memorandum. Now, what is the relevance of the difficulty? So you're sitting there as a prosecutor, you have to decide whether to introduce a statement, and you have a witness who says, look, I can tell you that I know this man for 10 years, and this is his modus operandi. I left before he left after the period in the indictment, by the way, because one of the incidents, Berea, is an incident that he witnessed. Yes, but he says, I know this man. I know his methods of torture. I know his methods of using policemen to extract cash from communities. I've been there. I witnessed it. So what's the problem they're talking about similar facts, that the prosecution will have a problem in establishing similar fact?
No, there's no problem at all. It's, I think the coining of this is wanting to justify the conclusion that they reached there. But even at the conclusion as they reached it, you'll see that it's not necessarily about that there is no evidence at all. It's they are talking about probative value, which at the decision-making stage is neither here nor there.
Yes, but I'm saying that if you are sitting there as a prosecutor, you have to make a decision, do I go ahead or not? And you think, well, there might be a challenge with similar fact. What's the issue there? I don't understand.
There's no issue at all, yes. Because you prepare yourself to go and meet that challenge in court and then prepare to argue.
Yes.
If the challenge comes anyway.
Yes.
Now here the challenge is being anticipated, that there is going to be this challenge, which is not apparent from the report, because it did not make any. The report did not make any reference to representations having been made by the accused or by the defense anyway.
Yes, well, because they've always avoided dealing with the merits of the case.
Indeed.
All these reviews never really engaged with the charges.
No.
Yes. Now it then says the hearsay statements of Ndlondlo, Mkhize, and Matonsi have its own challenges in respect of the low probative value and reliability of the statements. Now, if I can just stop here. We went through this case with the Ndlondlo statement. Mr. Ndlondlo had witnessed personally the exchange of money with Inspector Mostert and Major General Boysen. Mr. Matonsi had witnessed the collection of cash within the taxi association, which was intended to be paid to Major General Boysen and Mr. Inspector Mostert. But I don't understand why they are regarded as hearsay. Do you understand?
No, it's a misdirection, Chair. It can be, even if it's hearsay. That's why there is Section 3 of the Evidence Amendment Act.
No, but let's forget about it. We're going to deal with that now, assuming it's hearsay. But I'm talking about, you've got two witnesses. We went through Mr. Matonsi's statement. Mr. Matonsi was present when the money was collected. And he was present when it was said that the money is for Mr. Boysen. The only thing he didn't witness is the exchange, but it was witnessed by Mr. Ndlondlo.
Of course.
So where is the hearsay? I don't understand that.
It's not hearsay. I was answering, even if it's said to be hearsay, that it shouldn't be a problem.
Yes. Now, when they are talking about a hearsay statement, I mean, is that a misdirection?
It's a misdirection indeed.
Because that seems to be direct witnesses. I mean, there was, of course, a problem that Mr. Ndlondlo was subsequently killed after he gave his statement. And Mr. Matonsi was also killed after he gave his statement. And Mr. Bongani Mkhize, and I also don't understand the thing about Bongani Mkhize. He was a deponent in an affidavit which Major General Boysen criticized some aspects that they were hearsay. But all of those were then subsequently confirmed by the direct witnesses who were present when people were killed. So even in relation to that affidavit, it's unclear why it was regarded as hearsay.
It couldn't be hearsay, especially the one that would have been made in the process of court proceedings in respect of Bongani Mkhize. you know. Although at the time when the trial was going to be undertaken, he would have been dead. That statement of his would still be admissible.
Yes. So you've got then 3 witnesses that the Chauke panel claims to be hearsay. All of them are direct witnesses. The only thing that has changed now is because Mr. Mkhize was killed, Mr. Ndlondlo was killed, Mr. Matonsi was killed.
Yes.
All of them killed miraculously after giving statements. They are then murdered.
Yeah, indeed. And that those statements do not become inadmissible because the deponents thereof have died.
Yes.
They will still be admissible in the subsequent trial.
Yes. Now, how would this happen? Because they're talking here about low probative value and reliability of the statements. Now, I struggle to understand that because in the case of Mr. Mkhize, there are in fact admissions made by Major General Boyson in his own answering affidavit. Now, how would a court deal with those admissions if you were to prosecute Major General Boyson and you put his own affidavit to him that here you admitted this fact? How would that make it a low probative value?
It's a misdirection in itself because when you put a statement to the maker, it can't be a low probative value. Can't.
Yes.
Yes.
And his statements were made under oath.
Yes.
So the only thing that has happened is that the first opponent is dead, but Mr. Boyson is still alive,
Yes.
and he's made his admissions, and you can cross-examine him on that.
Indeed.
Yes. And then they're talking here low probative and reliability of the statements. Now, that I also don't understand. This was a statement made to a judge, and the judge accepted it, which is why the interdict was granted.
Indeed.
Yes. Now, how would you then go about the admissibility of the statement by Mr. Ndlondlo, who they managed to kill, and the statement by Mr. Matonsi, who they also managed to kill?
You let the evidence of those who took the statement and ask the court to consider them in terms of Section 3 of the Evidence Amendment Act.
And would you have a good explanation why the persons on whom the probative value of the statements depends, which is a requirement of the Law of Evidence Amendment Act of 1988, which says that by definition, it's a statement of someone on whose probative value the evidence depends, but that person is not giving evidence. So would you then have a good explanation that the reason he's not here is because he's dead?
He's dead, and
Yes.
the suspicion is that he would have died at the hands of those that are by being tried.
Well, Mr. Mkhize, there's no suspicion. He was killed by them. They admit that they killed him.
Indeed.
Yes. Where we don't know who killed them is Mr. Ndlondlo and Mr. Matonsi. But how they got killed in the middle of the trial after giving the statements is highly questionable.
But if you look at the patterns and like what happened with the killings, and like one could ask the court to draw an inference that they would have been killed in the process of all these other killings, whether taxi violence or them in being suspected to be involved in this Mapumulo Kwaduguza taxi violence.
Yes. Now look at what happens next in the next sentence. It says the prosecution would have difficulty in having these hearsay statements admitted as evidence. The application to have the hearsay evidence admitted will be unsuccessful. Will be unsuccessful. How does anyone say that an application for admission of a statement will be unsuccessful?
It's self-destructive.
But I mean, how do they know? The judge might admit that.
That's why I'm saying it's self-destructive. You can't even make an application in the circumstances where you think you're not going to be successful. But
I'm
here,
asking, how can you make that judgment as the person who wrote the report that I know for a fact that if I make an application, it will be unsuccessful? You're not even saying there is a probability that it may not succeed. You're saying it will not be successful.
That's what I'm saying, Chair. That it's highly unsustainable. The argument there, the proposition there is untenable.
What I also don't understand about their approach to hearsay, we looked at a judgment of the Constitutional Court in a case called Savoy, where the provisions of poker were challenged inter alia on the basis that they treat hearsay as a default position and not as an exception, as per the Law of Evidence Amendment Act of 1988. And the Constitutional Court actually upheld the provisions of poker. And it even explained that what that means is that the admission of hearsay is the rule. Its exclusion is the exception. Now, when I read this paragraph, how does that square up with that judgment of the Constitutional Court?
It's at odds. It's at odds with the ruling of the Constitutional Court.
Yes. Why?
Because it's actually recommending that which the Constitutional Court says it's lawful, and then it's saying here they're saying it won't be admissible.
Yes, I understand. But I mean, the problem is about the test, you know. If poker, which is what the Constitutional Court says, if poker says, contrary to the Law of Evidence Amendment Act, hearsay is admissible. You as an accused can say it's not in the interest of justice. Unlike the usual position where you as the state, you know, must prove that it's in the interest of justice.
Yeah. So the test from the point of the state as the prosecution is you need to prove that it's in the interest of justice that the hearsay should be admitted. The contrary, the accused should indicate that it's not in the interest of state and it's prejudicial to him if the court were to admit that statement.
Yes, but that's the usual rule under the Law of Evidence Amendment Act.
Indeed.
Now, I'm talking about now the poker provisions, which say that the court must admit hearsay evidence.
Yes. So the test, as I say, on behalf of the state in this instance, that issue will not arise.
Exactly the point.
Yeah.
And here they seem to misunderstand the test where they say, no, you will have to apply for the admission. But the Act says that the evidence is admissible. And the accused can say it should be excluded because it's prejudicial.
Yes.
Well, what I find strange, Advocate Chauke, is that the report was prepared for the purpose of reconsidering the authorizations in terms of Section 2.1 of the poker. And one would have expected this senior lawyers who sought to advise Advocate Batoyi on this reconsideration to have looked at case law.
Yes.
And looked at the specific provisions of poker, the very legislation that they seek to invoke. One would have expected to look at all these authorities that Advocate Ngcukaitobi is speaking about, to the cases that had been dealt with in the High Court and the decisions of the Supreme Court of Appeal and the Constitutional Court. I mean, these are lawyers. Yes. So that they could give Advocate Batoyi a well-considered advice.
I agree, Chair.
But I look at this report and I see none of that.
Yes.
Or have you seen the relevant authorities cited here on these very critical issues?
No, Chair. No, even like Chair has indicated, the heading of the report, it's a reconsideration of the authorizations. That presupposes that Advocate Batoyi was actually reviewing a decision of her own office. She was reviewing herself, which is problematic in a sense.
That aside, when you get into that exercise to reconsider what your predecessor has done. One would expect that you will go and look into the legal principles that advances your case
Indeed.
for reconsideration and come into a totally different conclusion,
I agree.
as these advocates have done. And I'm saying, it seems to me that they never even looked into any of the authorities, the
Indeed.
case law authorities, on this critical aspect of the law that Advocate Ngcukaitobi is referring you to.
I agree, Chair. That's what is glaring obvious, and it appears glaringly that those High Court decisions were not considered.
Yes. Well, I mean, we know, Mr. Chauke, that they looked only at U.S. authorities exclusively. There is not a single South African authority they looked at. They even misapplied the U.S. authorities because they looked at a case in Florida, which has got a different wording to our poker here.
To their credit, Chair, they looked at government judgment.
Well, no. For purposes of deciding the test for poker, there's not a single South African authority deciding. When they looked at the government judgment, they excluded paragraph 38, 39, and 40. They didn't look at the Chasibi case. They didn't look at the Savoy case.
Indeed, I agree.
Now, this is the question that the chair is asking. I mean, how do you actually place any credibility to a report that is so glaringly misconceived?
It's a misnomer. It's unfortunate, but as you know, I know from where I'm sitting. In the past 7 years, it was the high-level dead-clearing the Coke report when some of us knew that there are serious problems with this report anyway.
Yes, but I asked Advocate Batoyi, that the most obvious thing would have been to ask the advocates that are representing her in the racketeering charges, which in this case was Advocate Hilton Epstein. And then she was vague about that until we found out that she did speak to Advocate Hilton Epstein, and Advocate Hilton Epstein was not in support of the retraction of the charges. That was the whole problem.
Yes, and remember, that was concealed, or it was not disclosed to the panel that she actually met with the legal representative who were representing the state or the NDPP's office in that review proceedings. It came out once she was asked about that.
Yes.
I beg your pardon,
Yes.
Counsel. As I understand the report, I think the challenge might have started right from paragraph 167 and probably elsewhere after they dealt with the USA authorities. You see in paragraph 167?
Yes. I'm there, Chair.
You can read that paragraph.
That after paragraph 166, where there's a reference to the U.S. courts. 167, 167.
167.
The prosecution does not at any stage explain how the accused that were not charged with racketeering knowingly performed activities helpful to the operation of the criminal enterprise. There is in any event no evidence in the dockets to substantiate an averment that the accused performed activity
Given rise to the draft terms of reference, which speaks of principles regarding hearsay, unsigned statements. They had forgotten that they are dealing with poker. Correct?
It seems so, Chair.
And
I
as
agree.
counsel is saying, had they then had regard to the poker principles there and looked at the case law, South African case law, they would probably have thought otherwise. Now we have the terms of reference that echoes this very paragraph. And yet this paragraph says there is in any event no evidence in the docket But we don't even have a summary or an analysis of those dockets in this report. So that Advocate Batoi, who did not read the dockets herself, could have a sense of what evidence was contained in those dockets. Is that not a problem?
That is a problem, Chair.
Here.
Indeed.
Thank you.
Thank you, Madam Chair. Yes. So have to complete this section. We were at paragraph 241 where they just make an assertion that an application for the admission of hearsay will be unsuccessful. And then it says, paragraph 242, there appeared to be undue haste on the part of the prosecutors to obtain the racketeering authorizations. Yeah, Chauke. Yes. Now, the certificate was signed only the following year in August, almost a year of painstaking investigation before the prosecutors were satisfied that they have enough now to sign a racketeering certificate. Advocate Mayema was here. He spoke about meetings that were held between right up to June when the draft indictment was held. But even there, they were still not happy. They still had further discussions until August. He spoke about interactions with experts to help them along, about visiting the victims, taking statements. Eventually, the indictment was just hundreds and hundreds of pages. The prosecution memorandum was itself in excess of 100 pages. The response to the request for further particulars was itself 200 pages. Now, an allegation like this made by people that are sitting in an office that the prosecutors were unduly hasty in obtaining racketeering authorization. Is this a fair statement?
Very unfair and unfortunate.
Yes. You know, one of the things I don't understand what the NDPP was doing here, the impact of what she is doing on the ability of the NPA to prosecute organized crime. What is the effect of this? That, you know, she's not applying the law, she's disciplining people that are trying to apply the law. Now we hear that they've been consulting extensively with Major General Boysen, somebody who is a criminal suspect. I just don't understand what's happening.
This Katomania case is a bad example of how the NPA should behave in terms of where they need to prosecute or not to prosecute. Take out the issue of then in 2012 when Advocate Jiba would have issued. Another 4 years thereafter, the NDPP, Sean Abrahams, do exactly the same thing to say this matter should see its light at the end of the tunnel. And unfortunately, for reasons that are not obvious, other than that there was this hype that everybody seemed to buy the narrative that there's no case. The case was just simply withdrawn, and people had to find justification for them to be able to withdraw that case. And once you do those kind of things, this is what you see. And it affects the confidence that the public will have in the NPA about what kind of decisions do we make in respect of prosecution of organized crime.
Yes, but I'm talking about institutionally, the organization itself, the damage that you cause to an institution. If you target your own people for doing their jobs, that's what I want to comment on.
It's unfortunate, and then you have the prosecutors or advocates who will be afraid to make decisions in respect of this kind of crimes, because they will be thinking that they will be subjected to misconduct, and their careers will be affected because of the decisions that they make.
And then this idea that, you can work with, people throw around a lot of phrases, state capture this, but you can work with a potential criminal suspect, right, to build up a case to purge prosecutors inside the organization. I really struggle to understand this. I'm serious when I say that.
Let me be direct with this specific case.
Yes, we're talking about the fact that they are working with Major General Boysen to get people like yourself purged out of the system.
Yeah.
Major General Boysen was once a criminal suspect. He remains a criminal suspect even now.
Yeah. General Boysen was the head of the organized crime in KZN. Advocate Ngcukaitobi was the DPP in KZN at the time, and even at the time of all this, most of all these incidences. And in the nature of work as the DPP, you will meet and work with the heads of institutions. And in this case, that working relationship appears to have played a role between Major General Boysen and Advocate Ngcukaitobi.
Yes, but I'm making more a principled point that the impact of the NPA going out of its way to forge a relationship, if in this inquiry, forge a relationship with Major General Boysen to assist them to find a case against you.
It's highly deplorable.
Yes.
Highly deplorable, and in fact, I'm using the simple term, but it's more deeper than that. That you become an accused at the expense of a criminal.
Yes.
But look at what the president tells you in his letter, your annexure AC6. AC6 to your affidavit,
Yes.
paragraph 5. In relation to this very point that council is addressing,
Yes.
paragraph 5, would you like to read that into the record?
The NPA is a constitutional entity, and its work is central in the fight against crime, including corruption. As the NPA is an integral part of the criminal justice system, your obligations as a director of public prosecutions warrant that the integrity of the NPA be preserved at all times.
Your comment? Your comment?
I fully embrace what the president is conveying to me. But at the same time, the worry and concern that I have was the inclusion of the word corruption in the context of me having been addressed, because as I'm sitting here, I'm also not aware that I'm facing any allegations of corruption.
Well, I mean, we know for a fact you are not facing allegations of corruption. So there's nothing about not being aware of that. You are aware that you are not facing corruption.
The council repeated yesterday that move away from the Zondo Capture Commission statements. Zondo Commission didn't make any findings against you, and you need not really concern yourself about issues of corruption. I think council said it again and again yesterday. But I just wanted you just to comment on this statement. That seems to be so apt to the very point that council is making now. And that's why I sought your comment on this very opposite point that the President is making.
My apologies, Chair.
No, you need not apologize.
I-
I think you have said that, if I understood your answer to say, you fully agree with the sentiment expressed by the President.
Indeed.
Insofar as the position or the role of the NPA is concerned in relation to its role of fighting crime.
I accept that. Take counsel on that. In fact, it's very profound that is what is expected of the NPA as an institution.
And you now tell us, or you answer, that it is concerning that the head of the institution that seeks or is constitutionally obliged to fight crime seems to do the opposite.
Indeed, Chair. That's my view.
I'm saying seems.
Yes.
I'm putting it at that level. Seems to do the opposite.
Indeed, like counsel is indicating, at worst, if you don't agree that there is a case against the accused person and the case is withdrawn, that should be the end of the matter, and then life must go on. But to go to an extent there, you team up with a suspect to purge your own. It's very worrying. It can't describe an institution of government, let alone the NPA.
The least that one would expect from the head of the NPA, who has not even read the dockets concerned, would have been to allow this matter to be ventilated in the courts, so that finally the court, which is the appropriate forums to deal with these very issues, intricate issues, as far as poker is concerned, could finally decide.
I agree, especially in this matter, which was so high profile, where many lives were lost at the hands of those who were supposed to protect them.
Yes.
Beg pardon, Counsel. And when you look at paragraph 9 of the President's letter, the very letter I've referred to, 68-39, if you may also read it into the record.
Paragraph 9, I have carefully considered the allegations leveled against you. I am of the view that the allegations need to be independently and impartially investigated by an inquiry established in terms of Section 12, subsection 6A of the NPA Act. As such, I have decided to institute an inquiry in terms of Section 12, subsection 6A of the NPA Act to inquire your fitness to hold the office of Director of Public Prosecutions.
Do you want to comment then?
I agree, and it's fair that if the President is placed in a position where there is this serious allegations which concerns a Director of Public Prosecution, they indeed had to be investigated for the integrity of the NPA and for the integrity of the person that is affected, in this case myself.
Thank you.
Thank you, Madam Chair. What about the words independently and impartially?
I accept that the inquiry, as it were, and as instituted by the President, is able to independently and partially investigate these issues that are before the inquiry.
Yes, thank you very much. Now,
maybe I should say something.
Yes, please, carry on.
I'm aware, and this is even on record, that the NDPP, Advocate Chauke, addressed the NPA and prosecutors at VGM, in which she said something about the conduct of these proceedings and what is happening to her, that she's being bullied by the panel and what have you. And that is unfortunate.
Well, she will come back and explain herself. Now,
If she does?
if she does indeed. Can we just complete then? We've dealt with this paragraph 242, where there is this idea that the prosecutors were doing something wrong by fulfilling their obligations under the Constitution, which is to prosecute without fear, favor, or prejudice. And that comes from the head of the prosecution, who has come to this inquiry with a potential criminal suspect as their main witness. Now, paragraph 243, the investigation, both in respect of the racketeering and predicate offenses, are incomplete. Now, this statement, I found it remarkable. The people that are writing this are saying the investigations are incomplete, but then they recommend the withdrawal of the charges. What is your comment on that?
It's very unfortunate and improper. With respect, it looks like my colleagues did not go in depth into the evidential material that were contained in the case dockets, because you can't say an investigation in respect of Mkhize's death, and investigation in respect of Kwazindlovu, and investigation in respect of Magojela, and in respect of the Biela brothers is incomplete. It can't be.
Yes. But I mean, let us assume they were correct. I understand what you're saying. For instance, in Bheki Temba, we've been given an incomplete docket. And then in relation to the killing of Mr. Chauke, apparently the only person with some portions from the docket is the one evidence leader. And it's unclear where he got them from, and it's because he won't disclose his sources. The dockets are there somewhere. They're being hidden from the panel. But assuming that it's true that these are incomplete, how do you then say, let's close the file and withdraw the charges, instead of saying, okay, find document A, B, C?
No, in fact, what is happening in this inquiry is not that the investigations were not complete. It's that evidence of investigations were complete is being suppressed in this inquiry.
Yes.
Okay. Now that's why you like you indicated, I've got no doubt in my mind that once an evidence leader has got the statements which he says he has got, he would have gotten them from the accused and nowhere else. If he can't disclose that they are from the NPA, because the NPA said they don't have those statements.
Yes. Look, I think the NPA is innocent on this. They have shown us the statement directly from the police station.
Indeed.
Which shows that they've tried to go to the police station and the police do not have it. But the point is this, the NPA doesn't have the dockets. Yes. The police station doesn't have the docket. And then one evidence leader has portions from the docket, but he will not disclose the sources.
The docket that the NPA says does not have. So in the process of prosecution, when you decide to prosecute, you disclose the contents of the dockets to the defense, to the accused, and you remain with the copy.
Yes.
So once you remain with the copy and the copy is lost, the thing that you will do is either go to the police station to get a copy, or to go to the defense to say, we have provided you with a copy, we have lost our copy, can you give us the copy? There's no other way where you're going to get it.
Yes. Now, this idea then that, well, even the investigation on the predicate offenses, because that's where the whole thing becomes relevant, because you then have to find the justification for the killing of 6 people is the killing of Mr. Chauke, the justification for the killing of an additional 5 is the killing of Mr.
Nkosi Zondi.
Yes. And then in the Nkosi Zondi, we have 105 pages. The rest and not to be found. And then in the one, we've got nothing except there's scraps of paper that Mr. Mutlamunyane has. Now, where would this be? I don't understand. You come from the system, you can educate us.
I'm saying to you
Yes.
that those you can only get them from the accused.
Okay.
If the NPA and the police themselves do not have them.
Yes, but how does this work? There is a point at which a docket is at a police station.
Yes.
There is a point at which it is with the NPA.
Yes.
There is somewhere where it must be electronic.
Electronic things is a new phenomenon in the past 6-7 years and whatever. But in those days, these electronic things, electronic dockets, ticketing system was not necessarily available. But in this specific case, as I say, copies would have been made and preserved. But unfortunately, in the space of things, dockets do get lost one way or another, and we need to investigate how they got lost. But in this instance, it's just unfortunate that you will have one section of a particular stakeholder in this instance having information that the others do not have, and then they will not necessarily disclose. I'm not so sure whether that is privileged or not. I'm not so sure. You can school me in respect.
No, there's nothing privileged.
Madam Chair, with your permission, may I come in there? Because Advocate Ngcukaitobi is referring to me by name. I'm the one who had those portions. And there was never at any stage where it came to a point where I was asked as to where I got them. I never, at any stage, pretended not to want to disclose where I found them. At any stage, if that came up, I would have disclosed my source. It's not a secret. And I've also asked the person from whom I got them to make the docket available. And he replied me and said, "Will do." So the insinuation that I was hiding, I know where the docket is and perhaps I'm colluding with some people, it cannot be correct.
I think it was during the cross-examination of... Let's find it there.
Advocate Mutlamunyane, if I may, I think we might need to check the transcript, but I think that question was posed to you and you said at that stage you are not prepared to disclose where the documents came from. I think I'll have to confirm with the transcript. I'm not too sure about that, but I know there was a bit of an exchange during when you produced the documents, but we ended up not knowing where you got the documents and what was your source. We might have to go back to the transcript. And I take it you do not quarrel with the fact that you are the only one who have the documents. It's just that you are quarreling with being called by name and also that you were not asked where the documents come from.
I'm quarreling with the insinuation that I was hiding, because Advocate Ngcukaitobi is insinuating that I did not want to disclose where I got the documents. It cannot be correct.
Madam Chair,
Let me,
I think the best. Sorry.
we had a long debate about those documents, if you remember, Council, and we even asked Advocate Lekgeto whether those documents emanated from the NPA. And I can remember what she said. She said, no, those were your documents. So perhaps what we should do, I'm not anticipating what you're going to propose, Council, is to look at the transcript when we adjourn. Then we can revisit this point. But Advocate Ngcukaitobi, tell us what you think.
No, I agree, Madam Chair. If the transcript shows that my learned friend was not asked where the documents came from, I will withdraw and apologize. If the transcript shows that he was asked and he refused to disclose his sources, then he has a lot of explaining to do.
I propose, and my sisters agree, that we park this point. When we reconvene after lunch, we will start with this objection. All of us must look at the transcript and come and address this issue.
Madam Chair, it is 15:15. It might be a convenient time, bearing in mind that the temperatures are up.
The temperatures are only yours is up. Yes, Advocate Ngcukaitobi. Thank you, Advocate Matlamunyani. We will take an early lunch break. That will enable all of us to look at the transcript and have lunch. Then we'll deal with this aspect when we reconvene. Advocate Chauke, remember you are still under oath. We will adjourn until 2:30. We'll adjourn.
Thank you, Chair. I still under oath.
Good afternoon, all. Good afternoon, Advocate Chauke.
Good afternoon, Chair.
Advocate Ngcukaitobi.
Thank you, Madam Chair. Madam Chair, to start with the subject we left hanging, I've asked my team to find the exchanges of that day. They have found day 39, the 6th of March 2026, at page 12.
Yes, Council.
Where the following exchange takes place. Advocate Baloy Mere, right at the beginning of the page. Advocate Mutlamunyane, can I find out these documents? You obviously found them from somewhere. Advocate Mutlamunyane, yes, from someone. Advocate Baloy Mere, from someone. Advocate Mutlamunyane, yes, from someone. Advocate Baloy Mere, and that someone will obviously come to testify on these documents. Advocate Mutlamunyane, not necessarily. Chairperson, how possible is that? It goes on and on. So the idea that they were not asked to confirm the sources seems to be contradicted by the record. So Mr. Mutlamunyane can take whatever steps he wishes to take, but the question is a legitimate one.
Let me understand the point of objection. Advocate Mutlamunyane, what is your point of objection exactly?
My point is, Madam Chair, from what Advocate Ngcukaitobi SC is suggesting, it would appear he is insinuating that I'm suppressing evidence and I'm refusing to give the source. Nowhere in this record have I refused to give a source. As evidence leaders, Madam Chair,
Let's not take much time on that. We have read the transcript, and as we understand this transcript, there is nowhere, Advocate Ngcukaitobi, where Advocate Mutlamunyane was asked where he got the documents from. Is that your concern? Is that your concern?
My concern is, Madam Chair, that I never ever said I will not disclose my source. I never said that. Because the insinuation by Advocate Ngcukaitobi is that we are suppressing documents, we are suppressing evidence, and I've not disclosed my source. I've never refused to disclose my source. I went out there as evidence leaders, as an evidence leader, to try and assist this inquiry by going out and getting witnesses. Inquiry, we don't have investigators, we do it ourselves.
Yes, understand that. I don't want us to get out of the issue because we must settle it and proceed. Can we agree on this before we roll out?
Yes, we can agree on that, Madam Chair. As I say, the fact of the matter is that there was no disclosure of the source. I take it no further than that.
We will make a ruling that in the transcript there is no suggestion that Advocate Mutlamunyane had been asked to give the source of the document. I think that's how far we can take it.
Thank you, Madam Chair. I'm not taking it beyond that.
Thanks, Madam Chair.
Yes.
But I would like to go further outside this ruling that Advocate Mutlamunyane, where did you find the document? Because if you look at the transcript, from the debate we had with you and Advocate Lekgetho, following Advocate Ramokhale's objection to your handing up the documents, we had that long exchange. And Advocate Lekgetho made it clear that indeed this document, the Konko's docket, had been searched by the KZN police and the NPA, they couldn't find the document. To the extent that the station commander, KZN, prepared an affidavit that was handed to you by Advocate Chauke to say they cannot locate the document. Efforts were made by the NPA even to search or to inquire from IPIT. So this document has not been available and has been searched for by several people, and it resurfaced that day. What we found strange, Advocate Mhlamunyane, and I don't want to repeat what we said. We were in chambers. You never disclosed to us about the disclosure that you wanted to make of that very document that came from the Tonto's docket. You had neither spoken to the Chauke's team about it, and you took all of us by surprise. Hence the objection. So we should not find ourselves spending time on issues such as this. I request all of you. We must take this panel into your confidence, both teams, and disclose documents. If I may ask you now, what is the source of that document? Where did you find it? Because everybody has been looking for it.
I'll speak for myself. In my attempt to assist the inquiry, when we consult with witnesses, I usually ask them as to whether they can provide any documents that can assist.
No, but let's get to the point. My question is very straightforward, Mr. Mhlamunyane. Where did you find the document? Because everybody is saying we have not found the document.
I'm getting there, Madam Chair.
No, but we can't spend so much time on the simple question. Where did you find it?
I was referred to an officer, Paul Mostert.
Paul Mostert?
Yes, who was one of the Katomana officers.
Yes.
And he provided these documents to me. I requested for documents that can assist me in cross-examination.
So it's Paul Mostert who gave you the document?
Yes.
Yes, thank you.
Yes.
Please proceed, Advocate
Yes. Thank you, Madam Chair.
Ngcukaitobi.
You know, Mr. Chauke, has he been warned or has not been? Has he been warned? I don't know. Yes.
Please bear with me. I was trying to locate where we ended when this issue arose. Advocate Chauke,
Yes, Chair.
please bear with us, the panel and the advocates. You've been watching this exchange and sitting there patiently. You remain under oath.
Thank you, Chair. I confirm.
Thank you, Madam Chair. I think, Mr. Chauke, maybe you can comment on this. Your speculation was that these documents could have only come from the accused.
Yes,
Now,
indeed.
for the first time after, I think, 7 months, we are told that the Congo docket is sitting with Mr. Paul Mostert. What is your comment on that?
Very, very unfortunate. Very unfortunate that the NPA and the police stations themselves, they do not have that docket and sitting with an accused person. All
Mr.
I can say
Mostert,
is just unfortunate.
I think Mr. Mostert has 13 murder charges against him. 13 murder charges. He killed 13 people.
Yes.
And so that's the person the NPA is using, sorry, not the NPA, the evidence leaders are using in these proceedings.
I understand so.
Madam Chair, I object to that. I object to that proposition that my learned colleague is putting to the witness. We are evidence leaders who have no interest in a matter. we must be seen to be neutral, and we try our best at all material times, Madam Chair, to be neutral. We cannot be seen to be blemished in the manner in which my learned colleague is doing. The document has not been sitting with me. I asked for documents that could assist me in my cross-examination of Shamila Williams, Miss Shamila Williams. And these are the documents that I got. Now it appears my learned friend wants to suggest, it's suggestive. What he's saying is suggestive that I knew all the time where the documents were. I have no business, really.
Well, he says you are using Paul Mostert. That's what you are objecting to?
Yes, I'm not using Paul Mostert, Madam Chair. I was referred to Paul Mostert when I was consulting with Johan Boezen. And now it appears a picture is now being painted before this inquiry and before the public that we're consulting with criminals, with suspects.
Don't put words into counsels. It's better to just focus on the point that you are objecting to, and not say things that you are being, a suggestion is made that you are consulting with criminals and all that. He did not say that. So let's just confine ourselves to what you are objecting to. Please.
As it pleases you, Madam Chair, I'll leave it at that.
Madam Chair, the person I am talking about is Paul Mostert. There are 13 murder charges against him. That is a fact. He is the source of the evidence leaders. That too is a fact. That's what I want Mr. Chauke to comment on.
I confirm that is amongst the suspects who have been arrested and were indicted to appear in the High Court.
Yes, but on 13 murder charges, killed 13 people.
Yes.
Yes. Now,
Advocate Ngcukaitobi,
yes.
isn't it that it is an allegation for now because he is a suspect? No court has pronounced that he killed 13 people.
No, it's common cause that he killed 13 people. The question is whether that killing was murder or not.
Oh,
Yes, but it's
okay.
common cause everywhere. He killed 13 people.
Okay. Well, the question is whether it's murder or it's...
Or self-defense. Yes, but he killed 13 people. He accepts that.
Okay.
I'm simply saying that the NPA, well, not the NPA, the evidence leaders are using that person as the source. That's the only point I wanted to comment on.
Indeed. I'm saying I understand where this background of this thing is coming from, and when suspects would have to be consulted because apparently it's the understanding of the NPA that there's no case against them. So they will probably want to use them to purge the prosecutors at their expense.
Let me understand, Advocate Chauke, before we make a ruling. The source of this document is from Mr. Mostert, who is an accused, or one of the accused, in the Katomena matter.
Yes.
Ordinarily, where will these dockets be? All the dockets, including the Tonto docket.
They will be with the investigation team. In this instance, because the case would have been withdrawn and the charges were withdrawn, they would have been filed back to the various police stations from the IP, then from the investigation team of the DPCI that were investigating the matters. Once the NDPP and the Director of Public Prosecutions have decided that no prosecution should follow.
So, meaning, if I understand you correctly, the relevant police station will be having those dockets.
That's how I understand it, that they would have been filed back at the police stations where they emanated.
Does it then make sense that the NPA went to the station commander KZN to look for this docket?
That's how I understood that. That is where you need to trace them once you want the docket.
But to no avail, as you know.
To no avail. That's how I understood the response from the NPA.
And ultimately, NPA, in its effort to trace this docket, was going to ascertain or to search or to find out from the IPD
Yes.
about the whereabouts of this docket.
Yes.
How does a docket then end with an accused person? Does it happen?
Yeah, it can happen that the attorney of record who was representing the accused would have been served with the copies of the dockets at disclosure. So probably the accused might have gotten the copies of those dockets from his defense attorney, who disclosure would have been made to.
And in this instance, the evidence leaders whose task is to gather information would have been entitled to receive that document from wherever it was sourced, let's say from Mr. Mostert in this case. As he was made to believe that Mr. Mostert had the document.
Yes. That's how I understand it, that they will be in a position to get it. If Mr. Mostert got it from his attorney or from IPD and he's having it, he will probably be, when he's asked, will say, I have it, I can provide it.
So given these circumstances, following your answers, it is not unheard of that an evidence leader in the position of Mr. Motlamunyani would have then received this document from one of the accused persons.
No, not. I think what is problematic now from
No,
one
just
sitting.
answer the question first.
No.
Then elaborate.
No.
No.
Yes.
And what did you want to say?
I wanted to say in the circumstances where we are, that the NPA and everybody was looking for them, they couldn't get it. It was a concern. But I think bravo that the evidence leader could get it outside of everybody.
But if he consulted with Mr. Boysons, as he did,
Yes.
Mr. Motlamunyani,
Yes.
and maybe all others
Yes.
who are supposedly lined up for testifying, that will not be unheard of.
Indeed, that's how I understand it.
Counsel, both of you, following my questions and answers by Advocate Chauke, the objection is sustained.
Please,
Thank you,
Madam Chair.
Can I ask you
Before
this?
you proceed, Dr. Motlamunyani, I want to make it clear and place it on record to both of you. We cannot be sitting here complaining about each and every issue. Let us get to the chase and get to the crux of the matter. It does happen between lawyers that we don't agree about how we address one another, what language, unless it is very, very serious. But if we are seen in a public stage like this, when we are complaining about everything, Dr. Motlamunyani, let us please try to not to do that. As you know, litigation, we all need to have hard skins and bear with each other. You can discuss these things outside this hearing, and it does happen. We get out of court, you are not happy with what your colleagues did, you go and have coffee. It happens every day. I'm just requesting both of you, Nkabinde Ngcukaitobi, let me also caution you.
Yes.
I know these issues that we talk about, most of you feel very sensitive about them. but let us try to maintain the decorum that we are all expected to maintain. After all, we are all officers of court. When we emerge out of here, the public will judge all of us in the manner we behave here. So I request you, as senior counsel, to make our task easy and not to make determination on each and every thing. We have substantive applications to adjudicate upon instead of focusing on the real core issue, this inquiry. I request you, and I'm sure I'm speaking on behalf of my sisters, if they wish to say anything before you proceed, they may.
I think it's well said. Thank you, Chair.
Thank you to both of you, Counsel. Dr. Chauke, thank you.
Thank
you
you,
may
Chair.
proceed, Counsel.
Thank you, Madam Chair. Mr. Chauke, I think this is the right time. I'll still come back to those conclusory paragraphs, but I think the point of the discussion right now requires me to take you to page 70 of that report. 70 at the bottom left. Do you have that?
I'm there, Chair.
Yes. Now, this is the section in the report where there is a discussion on some of the dockets, not all, but some of the dockets. But the context in which the discussion is taking place is in paragraph 191, where they say the prosecution team alleged in the October 2015 memorandum that in their analysis of the modus operandi of the accused, that the tracking or tracing of the suspects for questioning happened without shreds of evidence linking them to any offense. They also allege that the accused also killed civilians and or suspects without any tangible evidence against them and in the absence of warrants of arrest for the suspects. So what they are trying to do is to say, look, your claim that the suspects are killed without linking them to the offenses being committed is unfounded, correct? Accept that.
Yes.
It's in that context that the Maphumulo docket is mentioned. If you look at paragraph 192.1.1, okay?
Yes, the Maphumulo case 99/9/2008.
Now, they say in the docket Maphumulo case 99/9/2008, the murder docket of Superintendent Ngcukaitobi, correct?
Yes.
Now, can I ask you if Mr. Paul Mostert was a suspect in the killing of Mr. Ngcukaitobi?
From the top of my head now, I cannot check. I might have to refer to the indictment to.
No, Mr. Ngcukaitobi's killing is not part of the indictment. Remember, it was a trigger for the killing.
Yeah.
The same as the killing of Mr. Zondi.
Yes.
Yes. Now, I ask you the question again. Is Mr. Paul Mostert an accused in the killing of Mr. Ngcukaitobi?
No.
Exactly the point. Why on earth is he going around with this docket?
I may just suspect that maybe because it's a police or this docket, because it did not form part of the indictments, and they would have access to them in the scope of them being police.
Precisely. That's the only explanation, is that he has access to it in the course and scope of being a police officer.
Yes.
The station doesn't have it, the NPA do not have it. Mr. Paul Mostert, who's not an accused, has it.
I see. Yeah, that's what it is.
Yes. And now you have here a strange scenario. This report is prepared by the NPA, correct?
Yes.
Which means that as of June 2019, they had this docket.
Yes.
Yes. They don't have it now.
From the confirmation that the NPA made, yes.
Yes, well, they told us, Ms. Lekgetho told us they don't have it.
Yes.
And we had a letter from Mr. Anton du Plessis that they don't have it.
The Deputy National Director of Public Prosecutions
Yes.
there.
This is the point, is that they had the docket. in June 2019.
Yes.
So this is the point. How does this thing happen that you have a docket, 4 people are working on it, and then it vanishes?
That's very strange.
But how would this happen? I mean, because the dockets we ended up getting, the 23 that we ended up docket, I know there are many problems with missing information, etc., but they are all sent to us in an electronic form.
Yes, it should follow that if the Chauke panel also considered this case docket, it would have formed part of the ones that would have been on the electronic registers of the electronic storage of the NPA.
Yes, this is why this thing is very difficult to explain, that the NPA, which had it and purports to have analyzed it, doesn't have it. Then someone who's not an accused has it.
The one who's not an accused. And
In that docket.
In that docket has it, yes.
Yes. Now, they then talk about a statement that is coming under oath from the witness. They talk about cell phone records. The whole paragraph 192.1.2.3, the whole of that up until 192.1.6, purports to extrapolate information from this docket that is in the possession of Mr. Paul Mostert. Now, you have many alternatives, well, perhaps only 2 alternatives. The one is that these people who drafted this report also consulted with Mr. Paul Mostert, and he gave it to them. Or they got it from somewhere else, and then through negligence, they've now lost it.
Yeah, I can accept that because there's no indication that they consulted the witnesses. They consulted the dockets and statements and the like. So I would take it that maybe they worked on it and then somehow it got lost after they've worked on it.
Someone must have given it to them. I'm saying the source could also be Mr. Paul Mostert. It's very difficult to know.
No, it's very difficult to know. I'm taking here on the assumption that the Chauke panel said that they received the case dockets, they received the prosecution memorandum, and they started working on this docket.
But the point is this: the panel still does not have a proper explanation about this docket, because it's not enough for the NPA to say we don't have it, because they once had it.
Yeah, I agree.
Yes. And now it's getting scraps from this docket from Mr. Paul Mostert.
Very unfortunate.
And this is the crucial docket because it's a turning point in the conduct of these Ketomano police officers when they decided they were going to go on a killing spree.
Indeed, the justification was that all the guys who were supposed to be arrested and they shot at the police, it was because they were suspects in the killing of Superintendent Chauke.
Yes. But now we have a scenario where, because we don't have this docket, we can't make head or tail of the summary. Yes. Now, the same thing, is funny. The next case they analyze here is the killing of Nkosi Zondi from paragraph 192.21. 192.2, 192.2.3, 192.2.4. And then they conclude in 192.3. Now, these are the two crucial dockets. So this one is called Kwama Pumulo, the killing of Superintendent Chauke. This one is called Begitemba, the killing of Nkosi Zondi. Now, you recall, you've been part of these proceedings, the struggle it took for us to finally get the docket of the killing of Nkosi Zondi. When we finally got it, we found that it was only 105 pages. So many pages were missing.
Yes, I recall that.
Yes. But we also know now from the evidence of Mr. Mhlongo that these so-called confessions, how they were procured, the two that the NPA is relying upon in this report. You see, because look at what they're relying upon. There's somewhere where they're relying, oh yes, at 192.2.3. This information, now this is the information referred to at 192.2.2. about the assassination of Mr. Bongani Mkhize. They're saying this information was later confirmed by Mr. Swayo Mkhize as well as Spam Hlongo after their respective arrests. So, it says Mswayo, but I presume that is Swayo.
Yes.
Yes. Swayo Mkhize made a warning statement, confession, and pointing out the statements of Mkhize implicated the deceased Bongani Mkhize in the conspiracy to kill Zondi. They also identified Sibongile Badumile and Sifiso Ndimande, who were present when they planned to kill Zondi. The motive for the murder was that they believed that Zondi gave the police poison information on the whereabouts of Magojela Ndimande, who was killed in Howick Case 106/09/2008. This is the information we went through together with Mr. Mhlongo.
Yes.
Now, when was the Mhlongo trial? 2009?
2009.
Yes. At the end of that year, he was acquitted.
And this civil claim about two years later.
It was settled in 2016. Civil claim was settled in 2016, but
Yes.
the criminal trial was in 2009
Yes.
because he was detained from February 2009. I think he was acquitted in 2010.
Yes.
That record is all public, the judgment of Judge Giyanda. There is no attempt here in this report to consider the judgment which acquitted Mr. Mhlongo. There is an affidavit given by Mr. Swayo in which he retracted the so-called confession, which was accepted by the judge in the case of Mhlongo, not referred to at all.
Indeed.
The entire docket that we looked at from Mr. Mhlongo is just not referenced. It's as if it doesn't exist.
Indeed.
Yes. Now, I come back to to really what is the value of this report? It is relying on information which has been discredited for more than 15 years.
Yes, in fact, by 2019, when this report was made, it was made almost 3 years later, not 3 years after the police had settled the claim against them in respect of Mhlongo, and almost 8 years after his acquittal.
Yes. So the two crucial documents. One is this affidavit. Now, they're still saying, no, these people were implicated because of the confession by Mr. Swayo. But we know everything about the confession. It was retracted.
Yes.
Then they are also talking about the confessions made by other accused. But we know who those accused are. It's Mr. Mhlongo.
Yes.
And we know what happened to Mr. Mhlongo. Now, you have a scenario where the NPA, I'm not talking even about the police, the NPA is relying on information that has been obtained through torture. Because the authors of this report is Mr. de Kock, Mr. Tenga, Ms. Riley, Mr. Mamabolo. These are senior employees of the NPA.
Yes, in defense of the accused.
Whatever they were trying to do, whether they're doing good or bad, the fact of the matter is that information obtained through torture is unconstitutional. This is what used to happen under apartheid.
Indeed.
Now you have here the 4 senior prosecutors together with the National Director of Public Prosecution. They hoist this report around, but it's relying on information obtained through torture. And they don't tell anyone that there is a trial that declared the information inadmissible.
Very unfortunate.
Yes. You see, which is why they conclude in paragraph 192.3, in both the Congo and the Zondi murders, there was a prima facie case against the suspect. But we don't know anything about Congo because the docket is being hidden from us by Mr. Mostert. We know about Mr. Zondi because we've got some scraps of the docket. But we also know about that case because Mr. Mhlongo bothered to contact me and insist on testifying before this panel so he can tell the truth.
Yes.
Yes. And we know that the source of that information that was used to implicate people there was torture.
Yes.
And this is what they say is the prima facie case.
Very unfortunate.
Yes. Now, then you have their purported analysis after that of paragraph 192.4, Berea. You know what happened in Berea? You've been sitting here. But
Maybe before you go to that analysis, Advocate Ngcukaitobi, I should ask some questions, put some questions to Advocate Chauke. Advocate Chauke, I'm going to ask once more, I'm sure, about the life of a case docket that ends up at the NPA offices. The origin would have been the police station, am I correct?
Yes.
Then, in the context of this inquiry, it would then land at the DPP's office.
Yes.
And then it would land at the NPA's office.
At national office.
At national office.
Yes.
Now, what I'd like to know is when you send, and I'm talking about the DPP, sends a docket to the NDPP's office, would the DPP be left with a copy, or what is the position, or would it just go as that original docket moving from one station to the other up to the NDPP?
As a rule of practice, the DPP's office will make copies of the dockets.
So, which means that you would send the original docket to the NDPP without keeping a copy for the Director of Prosecution Station?
In general, if the DPP sends the docket to the national office, he or she will keep copies of that docket in her office.
So, ordinarily, the DPP would keep a copy and send the original to the NDPP.
Yes.
And would there then be, I see you are nodding, is that yes?
Yes.
Right, thank you. Now, would there be a register where there is, checking the trail, where the DPP would have then delivered the dockets to the NDPP and let them sign acknowledgement of receipt, or what is the position?
Yes, there will be a register where somebody will sign for the docket. In most cases, copies of dockets are sent to the NDPP for review. The original will be kept at the DPP's office.
Okay, so it is the copy that would be sent to the NDPP.
Yes.
The DPP would be sitting with the original
Yes.
docket.
Yes.
And that docket would not then obviously be at the police station. It would be sitting in the DPP's office.
Yes.
And once the NDPP makes a decision, taking into consideration that the NDPP would be sitting with a copy, does it become necessary for the NDPP to then return the docket to the DPP, or would the NDPP keep the docket at the NPA offices? What is the norm?
The NDPP, the copies that would have been sent to the NDPP will remain at National Office Archives. Yes.
So, which means at least there would be a likelihood of getting this docket at the archives NPA. If it can be found there, at least at the DPP
Yes.
office.
Yes.
Thank you.
But what I wanted to explain, Chair, is in the context of the general. This prosecution was a poker prosecution, so the prosecution team and the original dockets were all at the national office.
Okay, thank you. So the original, but then because my understanding is that this whole thing starts at the, even if it's racketeering or what, it would have started at the seat of the relevant DPP. Is that the case?
That is the case,
Exactly.
Chair.
Now that DPP would then have to recommend this issuance of the certificate of racketeering.
Yes.
And that DPP would be sitting with the copy, because this is a matter of national imperative or the jurisdiction of the NDPP. The DPP would then send the original docket to the NDPP's office.
Yes, that's why I was saying
Yeah.
that in respect of this, because it was a national project.
Yes,
So
yeah.
the dockets were actually being done from national office. The prosecution team that was now at the time of Advocate Sean Abrams were sitting at national office with these case dockets. So they were not at the DPP, not even at the case at NDPP.
By implication, even those that drew reports like the report presently under consideration would have had access to the original docket.
At
the
national
NPA.
office. Yes,
Thank you.
at national office, not at the DPP's office.
Yes, thank you.
Thank you. I wanted to ask you, Mr. Chauke, about paragraph 192.4. That's the Berea case. Now you look at the summary that's given here. Thabo Sunshine Msimango was arrested on Brighton Beach on a charge of armed robbery. He later escaped from members of the unit and the docket was registered. Now, this is the only thing that is said about Berea. Now, you remember the case of Berea. The gentleman jumped out of the window on the 4th floor. He was shot 3 times by Mr. Mostert.
Yes.
You see. Now, what do you say about this analysis here? I mean, is this any meaningful engagement with what happened in that case?
It's a whitewash.
Yes. Now, assuming that he was wanted for armed robbery, what is the justification of killing him?
There's none at all.
Yes. Then look at what they say then about Melmoth. Now, these are the 4 top officials in the NPA. It's them who are writing this, what we are dealing with here. 192.5, they're talking about Melmoth. Now, Melmoth, you remember, it's the Biela brothers. One of them is naked and is lying on a Rondaville veranda. And the other is younger than him. I think he was 17 years old. Is wearing blue and white shorts and is killed inside the Rondaville. The place is just full of blood.
Yes, that's where there were also shown photos of the police enjoying their drinks outside the homestead.
But there is a thorough report of ballistics by Mr. Mangena.
Yes.
Now look at what they say about this. They say Kanyisani Biela was also killed. According to the police, this person shot at them from one of the Rondavilles through the window. They then moved into the Rondaville and fired 1 round in the direction of the suspect as more shooting erupted. Now, is there any reference here to the reconstruction of the crime scene, which is evidence in the docket?
No.
Yes. Now, you see, on this point, I asked Advocate Batoy in relation to the killing of KwaZulu why her letter to the mother of the child did not refer, well, the mother through
Mary de Haas,
yes, did not refer to the evidence of the expert. She says it's because it was not in the docket. She never knew that it was there. It was, in fact, the first time in this inquiry that Advocate Batoy became aware that there was a report by Mr. Mangena. Now, this is the full extent of the analysis, this paragraph I've read to you. I mean, what do you say about this? And it also just doesn't make any references to all of the evidence pointing to the guilt of the accused.
No, it's a whitewash. And the last sentence there in that paragraph, 192.5, which says they then moved to the Rondaville and fired 1 round in the direction of the suspect as more shooting erupted.
Yes, I mean, this is a killing in the early hours of the morning. And the gentleman is naked. I mean, it's truly, truly bizarre. Then they talk about Phoenix. That's the killing of Mr. Nzuza. And then they say, well, he's wanted on various That's the only thing that is said here. There is nothing mentioned about whether the killing by the police was justified. I think this was also a Mostert special. Nothing at all in paragraph 192.6, which explains why the killing was justified. It just says, well, he was wanted on various offenses.
Indeed, one would be interested to hear the part of the authors of this report to say why the analysis of ballistic reports and the actual statement of the police were not analyzed as against the ballistic reports.
And then the same thing with Kwamashu 192.7. They here talk about, this is now the killing of Mr. Tabede, who was also known as Mtago. Then all the thing that is said here is that there was a reliable source that implicated him in a statement dated 26/11/2009. But again, nothing about why was the killing justified.
It's my proper reading of the analysis here. It moved on the assumption that all the killings by the police were justified. So all they need to do was to identify who has been killed and what. That is what the report is doing.
Yes, but the report is meant to show why your team, well, not your team, it was Mr. Mayema's team, but why the prosecution team was wrong in preferring the charges of racketeering, which include being in the racket and committing the predicates. That's what it's meant to do. And what you get is this, that there was a reliable source, no information about this reliable source, no information about how this reliable source linked, and no information about why the execution of this gentleman was justified.
Yes, Chair, even if there was a reliable source and indeed they killed those people, but still they had to be arrested.
Yes.
The
Then,
report, if you remember the paragraph 176 in relation to what they say, 167 rather,
yes,
that there was no evidence.
yes.
You can see with the summaries that you are referring us to, it seeks to corroborate that very statement, because when you read this paragraph, the summaries, they can only seek to corroborate paragraph 167 to say there was no evidence. Am I correct?
You are correct, Chair.
Advocate Chauke?
You are correct, Chair.
Yes. Thank you, Madam Chair. And then you look at probably one of the saddest, though one doesn't want to compare death. Death is death. It's as bad for an 18-year-old and it's as bad as for a 6-year-old. So maybe that's a wrong statement. But then you look at the killing of of the young man, KwaZindlovu, at how it is dealt with by these 4 senior prosecutors, 192.8. In Eskawini, look, there are also many spelling errors in this report. You know, people's names are misspelled, places' names are misspelled, the dockets' names are misspelled. It also just shows it was a bit of they just didn't care what they were doing, you know. So many errors, you know. Like now they can't spell Eskawini. They say Esikwanini.
I see that, Chair.
But yeah, you can do the same thing. You'll find so many errors in this report. The deceased was Kwazi Ndlovu. The police were investigating the matter related to Westfield, case 263-210, in which 9 prisoners escaped from Westfield Prison, Medium A, 7th floor, and then they give a date. They were following up on information of the suspect, Dili Mzimela, who escaped from Westfield. On their arrival at house number J63, they introduced themselves as the police and they entered the house. The deceased was killed. Mzimela later on made a statement in which he states that his family rented out the property to the Ndlovu family. Again, there's just no analysis here.
Yes, there's no analysis. If I remember well, Advocate Shamila Batoe, when she testified, she said she accepted all the decisions except for this one, where the matter was referred to trial and the accused Padayashu was acquitted.
Yes, I understand, but I'm talking about the report itself, that the report is so bad that it does not address the fact that this was a young boy that was sleeping on a couch watching television. And old men from the police force came with rifles and executed him in cold blood fashion.
Yes, and they claimed that he was pointing a gun at them.
And
And
after
in
that,
his
they
sleep.
planted a gun. Yes. After having shot him with an R5. And this is all you get from 4 very, very, very senior prosecutors.
Very unfortunate, especially for this young boy who was killed in that fashion. It's very unfortunate.
Yes, but what is it saying about the competencies that reside in the NPA? The NPA is a constitutional office. The people that are employed there are meant to do better than what they have done here.
Oh, you can Google even this report. You'll see how it's highly celebrated it has been for the past years.
When you say 4 senior prosecutors, you say it on the assumption that the report was unanimous,
Yes. Let me say 2. Yes.
or one.
Or 1. Thank you, Madam Chair. That's a big mistake.
I have a follow-up,
Contradicting myself.
especially on this matter in 192.8. There was later a statement by Mzimela. I'm not sure who Mzimela is, but I think even in testimony we were by, was it Advocate Maema or the ballistic, who flighted a picture of the area and showed us that the Ndlovu family had rented a house, a property nearby, because they were renovating their house.
Yes.
Which, I mean, common sense would then say or bring one to the conclusion that this was a question of mistaken identity, because they went into this house looking for a specific person. They were looking for Tilili Mzimela,
Yes.
Yes.
and the Mzimelas were not in that house. So
Yes.
it was the Ndlovus who were in the house, and a family member of the Ndlovus was killed.
Yes.
Was there, as far as you know, so my question would be twofold. Was there, as far as you know, an apology that was tendered to the Ndlovu family on behalf of SAPS? Or, as a prosecutor, does it ever happen where a mistake such as this one has occurred, where you would apologize or show remorse or talk to the family and explain to the family what happened?
In most instances, if something like this happens, you consult and update the families and bring them up to speed about what is happening in the process. Indicate your position as the NPA, as the prosecutor, to say this is what has happened, this is the resultant of this, and where necessary, tender an apology, especially in the sense where you would have realized that the prosecutor has got it completely wrong.
Did any of that happen in this instance?
Not that I'm aware of, Chair.
Thank you, Madam Paloima. In fact, Mr. Chauke, the NDPP, the most senior person, came here and said, well, we prosecuted the case, there was an acquittal. And when I asked her, why are you singling out this case? And she couldn't give me a straight answer. It seems that it was vindication for them, that there was no evidence. That's why there was an acquittal.
That's how I understood the evidence from Advocate Batu.
Yes. What she couldn't explain is why the evidence of Mr. Mangena was not used in the trial when he was available and willing to testify?
Unfortunately, the people who did the prosecution and that who submitted the reports to her, they failed her in that regard, because they should have made sure that they provide her with all the information in respect of that matter.
So I don't understand that. The letter was written by Mr. Haas to her.
Yes.
She wrote in her own name, justifying the decisions made by the prosecutors in that case. And when I asked her here, why was the evidence of Mr. Mangena not used, she couldn't explain. So why are you saying she was failed by someone else? That was her own decision.
I'm saying this because as we heard from the evidence that she asked for a report that came to her to explain what happened at the trial, which was forwarded to her by Advocate Msinyat, who had received it from the DPP of KZN, who had received the report of the Advocate Sangar,
Yes.
cannot remember, who did the actual prosecution, and who would have provided the reasons why that evidence was not considered. It's in that context that I'm saying that.
No, but you see, I would have expected that if you have a complaint from a member of the public, in fact, this is not a member of the public, this is the mother of the child,
Yes.
you would at least say, well, just give me the documents of this particular case, I want to look at them. You wouldn't look at one memorandum.
That's unfortunate. It's unfortunate, and given the history and the high profile of the matter and the decisions that she made then, one would have said she needed to go an extra mile, especially in the context of what the case involves.
Yes, I understand. But what I also couldn't work out there is why she learned here when she was being cross-examined that there was in fact a report of Captain Mangena.
That I understood that she considered that she did not read, and she does not read some of the things. I think that surprise came to her that's why she was surprised when she was sitting.
Not some of the things. He said she does not read the dockets.
Yes, yes, Chair.
But it also looks, Advocate Chauke, that it's not only her, it's also the authors of this report, because there is no engagement with that report here.
I agree.
Yes, this is what I really am perplexed by, and this is really an honest question. But how does the NPA actually work? Because the country entrusts so much responsibility on this institution. So no one reads the dockets, dockets go missing, decisions are just made without any assessment of the pros and the cons.
Very unfortunate, but the reality for me sitting here, this does not define the whole of the NPA in terms of how they do the work. Unfortunately, in this instance, this was done for all ulterior motives and whatever. It couldn't be. That the NPA as an organization will be described by this conduct of what happened in this specific report.
Yes. And then there's also Mr. Gwala that's referenced at 192.9 in the second Eskawini case, which again is spelled as Esikwanini. Then they're also talking about someone who went to do a pointing out. I can't remember whether this is the gentleman that they went to his house and they took him from a meeting, a community meeting, and they took him to his house and they murdered him inside the house.
I think that is the one, because there were two
Yes.
Estikawini
Yes.
incidents in the indictment.
Yes. Now, but again, we only have 5 lines here which don't tell us anything about why this murder, this killing rather, would have been justified, even under Standing Order 251 or under Section 49(2) of the Criminal Procedure Act.
Indeed, there's nothing.
Yes. And then then they say, well, this deceased had a pending case of an illegal firearm. I just don't understand. And then the police found a pump-action firearm lying between the mattress and the base. But we again know the story of these firearms, how they end up there. We have at least 3 eyewitnesses who saw the police planting the firearms.
Yes.
Yes. Oh, yes, in fact, I'm corrected on this one, that even this narrative is actually wrong, that this is Mr. Gwala who was wanted. Yes, I remember this case. This is exactly the one. This is the one they took someone from a community meeting.
Yes.
And they were looking for somebody called Bar.
Yes.
And this is not the guy called Bar.
Yes.
But they killed him.
Yes.
Yes. They don't even reflect that story here in this report.
Yes, like I said, once you do a whitewash thing, the thing that will dispel your intended conclusion, you will never mention that.
Yes.
Like it has been pointed out, once they started to say there is no evidence, so you couldn't, when you make an assessment, go and find evidence which contradicts your finding already that there's no evidence.
Yes, but at the very least, you would expect there will be honesty to the facts, even if you reason them away. There would be honesty in recording the facts accurately. And you would expect this from the NPA.
Yes, that is the expectation. But unfortunately, in this instance, because it was a whitewash, the facts, if you consider them, they will contradict. Just considering the facts without doing anything more, they will contradict the notion that there's no evidence.
Yes. Then there is then the second last case, 192.12. It's the same gentleman. There are several matters against him. Eskawini case 423, Eskawini case 196, Eskawini case 484, and more and more and more. Attempted murder, and attempted murder. Now, when I looked at this, it seems that what the modus operandi, in fact, it's similar to what Mr. Boysen wrote in his book, when he said that in relation to the killing of Mr. Bongani Mkhize, the gentleman who was driving a black Lexus. He says, well, the beans were spilled by Swayo. That's how he met his death. It says, if there's somebody who makes a confession against you, you can just be killed.
Very unfortunate.
Yes. And that's the kind of picture they were trying to create here against the deceased in the second Eskawini, Mr. Gwala.
Yes.
Who, in fact, they mistook from someone else.
Unfortunately, like I'm saying, if you look, the summaries here, which are done here, is to indicate that all these people were shooting at the police, and the police were justified to kill them.
No, but there is nothing here that says they were shooting at the police. Not a single one in the summaries.
No, in the opening of where they start dealing with the summaries, that's how I understood that they were saying that the suspects were killed once they were trying to shoot back at the police.
Yes, I thought that the only thing they said was that they were sought for offences. If you look at paragraph 192.2.
No, I take it. I think I was reading from their assessment of the indictment, yeah.
Yes, so the only thing here that is that they are sought for offences, but there is no analysis of the justification of the killing.
Yes.
Which you would expect, because Standing Order 251 says if the police has killed, it's up to the police to justify.
Yes.
And Section 49, subsection 2 says that if you overuse force, you become the aggressor.
Yes.
Yes. Now, so that takes us to Mr. Gwala. Then the next one is Mr. Majola in Escort. This is one of the gentlemen sought for so-called ATM bombings. You know, one of them is the one was found in a rubbish bin and then shot from the top there.
Yes, I remember that incident.
Yes. Now, again, the only thing that is said is that, well, he is a suspect in an ATM bombing. But who decides whether he should meet his maker or not? I mean, no one. The Constitution says no one, the state has no power to kill because of the right to life. But the police here and the NPA in particular, which worries me greatly, is that they seem to suggest that these people are sought for offences and therefore the killing is justified.
Very unfortunate.
And then, paragraph 193, this analysis clearly shows that all of the deceased either had cases pending or were being sought in connection with cases in order to be questioned or charged, and that the averment that the police traced or tracked the deceased without there being a shred of evidence against them is misleading. Now, it's very unclear why they say this. They have just analyzed the case of KwaZulu, which is the most glaring one. They have also just analyzed the case of Bar, also another glaring one, where these people had nothing to do with what was being sought.
Yes, as I say, once you start from the premise that there is no evidence, what follows thereafter should stick to what you have already concluded.
Yes. Now, then they have an issue with what they call killing of innocent civilians, which the police alleged were suspects. And then they talk about Kanyisani Biela and KwaZulu. And then they try to analyze that in 195 and 196. And then in 197, they say that in relation to the latter, and that's now Ndlovu, KwaZulu, we are of the opinion that the investigation should be concluded and a decision be made whether Padayache should be charged.
Yes.
But the other 17-year-old boy, they don't make a similar conclusion. That is Kanyisani Biela.
Yes.
Because they're talking about cartridges found in the Rondaville. But there's still no engagement with the expert report that reconstructed both of these scenes.
In the report, it's not there.
Yes. And you know, that then ends the analysis of the dockets. You go through this, you don't find any analysis of the dockets. Then you get at page 82, lack of proper investigation. One paragraph you find also just stuck in arbitrarily is the paragraph 200 that is talking about, you remember the lady, Miss Denise Harley, who witnessed the police planting a firearm. You know how she is then criticized in this report? It says there are, however, contradictions between her first and second statement she deposed to, and between her statements and that of the two accused who were arrested before the deceased, Ngaba Mdluli and Nganyiso Ntenze. Now, they allege this, they are now explaining the so-called contradiction. They allege that it was Mostert who came to look for the firearm in the quantum vehicle in which they were seated. A21 saw Mostert take out a .38 from under the seat. A22 overheard Mostert, this is now it's Paul Mostert who's killed 13 people, asking the other police officers for his spook. It appears like highly unlikely that Mostert would do this in front of the co-accused of the deceased. It also appears that Harley changed her version of the events to fit in with theirs. Initially, she said that the white male instructed the Indian male to shoot. She never said she saw him leaving and then returning. She also pertinently said Mostert came in afterwards and asked what happened. She never said he came in with the firearm and placed it in the room. In her 2012 statement, she refers to more than 2 white males who went into the bedroom and placed the firearm there. Now, that's the only analysis that is made. Now, the only eyewitness was there. You remember what happened to her? They put a blanket over her head, and then they killed the husband, and then they removed it.
Yes.
And then she says after they had removed it, she saw them putting a firearm. And now the prosecutors spent 3 paragraphs looking at her statement. But if you excluded her statement altogether, you would still be left with the analysis, the ballistics analysis.
Which corroborates that the deceased did not have a firearm.
Yes. But the way that this analysis is taking place is like, well, just attack the victims.
Yeah, in this instance, you see contrasting view between those who wanted to prosecute and those who did not want the prosecution to ensue.
Yes, but I mean, let us assume that you have because what's also strange about this, when you go to those statements, is that actually she never changes her basic view that she saw them planting a firearm. It just never changes. She does change about how many people walked in and out, etc. But this is in the middle of the night. She has been blindfolded effectively, and she is too traumatized because they've just killed her husband.
But it's also immaterial how many people went in there. If the people who went there to shoot, they themselves, they said they shot.
They admit
so
that
whether they are 4, 10, or 15, it's neither here nor there.
Yeah, so those contradictions will be immaterial.
Of course.
Yes, I see. So that's your point, that actually these contradictions they're talking about are irrelevant to the decision of whether there is a prima facie case.
Indeed.
Yes. Yes, so I came back then to this point that thereafter you don't find any assessment of these dockets. You see. Then you come to the section, page 86, where there is an attempt to deal with the ballistics report. Now, I'll show you something here about the ballistics, which we dealt with in full. The first thing is that Mr. Mangena gave us 23 ballistics reports. What you don't find here is an analysis of those reports. Mr. Stale, I think, gave us 10. Again, you don't find an analysis of Mr. Stale's reports. Can you say it yourself?
No, in fact, now that I'm looking at it closer, I'm just surprised that if they say ballistic evidence and then there is referring to LCR and they're like, I'm just concerned that maybe the interpretation and the analysis of ballistic is the understanding is not the same.
I'm not sure I understand. I'm saying between paragraph 220 and paragraph 227 is where they are addressing ballistics. The ballistics that the NPA was relying on is Mr. Stale and Mr. Mangena. Mr. Mangena having produced 23 reports and Mr. Stale having produced 10 reports. These paragraphs don't refer to any of those.
Yes, I see that. That's what I'm saying. I'm surprised that the heading is that ballistic evidence, but the actual ballistic evidence of Stale and Mangena is not what is being summarized.
Yes. And then in paragraph 221,
Council, sorry to interpose, paragraph 205. Do you understand what it means? If you may read it into the record first.
These allegations should be evaluated against the totality of the evidence in the docket. There is evidence in many dockets of prima facie residue found on the hands of the deceased.
Do you understand what they mean?
they are conveying to say most of the deceased in their hands there was primary residue of the firearms that were found with them.
Do you understand what the first sentence means? These allegations should be evaluated against the totality of the evidence in the docket.
Yes,
What does that mean?
I understand the allegations against the police. Yes. So the allegations that the prosecution team are making against the police should be evaluated against the totality of the evidence in the docket.
Do you understand what that means? In practical terms?
No, in practical terms, Madam, I don't necessarily follow.
Doesn't it mean that, and correct me if I'm wrong, doesn't it mean that this summaries that they have provided which seems to be in favor of the accused persons should be evaluated against the totality of the evidence that is contained in those very dockets that they are summarizing?
Yes.
Now, if that is the case, could they have come to the conclusions they have come?
I don't think so. If the totality of the evidence, as they say, is what is contained in the dockets, then the conclusion should completely be different.
The converse should be true.
Indeed, Chair.
As a follow-up, maybe the question should be, when this report was compiled, did the 4 prosecutors have all the dockets in front of them? And also, did the dockets have all the necessary evidence that is supposed to be in the docket? For example, the NDPP, the Advocate Batohi testified that she was seeing Captain Mangena's ballistic report for the first time. So I'm asking this question, and that doesn't that mean that these 4 prosecutors should have had all the dockets in front of them, and the dockets containing all the necessary evidence inside?
That is correct, because when, remember, Advocate Maema and Matenja, they were sitting at national office in the NDPP's office with all these dockets. So the assumption will be when this team was appointed to have a look in those dockets, they would have a look on those dockets that would have been in the custody and possession of Advocate Maema and the prosecution team.
And so, in conclusion to, and in responding to the chairperson's question, you said they would have come to a different conclusion.
Indeed.
Thank you.
Thank you. Now, I took you to the ballistics section, and I've showed you there that in the section where they must be dealing with ballistics, Mr. Mangena and Mr. Stale are not mentioned, correct?
Yes.
Now, then they make passive appearances. Firstly, at paragraph 208. 208, page 81, Madam Chair. Now, they say here, in an attempt to counter the defense that the deceased fired at them and were in possession of firearms. Statements were obtained from experts such as Stale, Captain Mangena, and Dr. Reggie Perumal. Stale was initially appointed as the defense's expert in some of the dockets. Can you just comment on that? Why is this an important fact that they must mention?
Because Stale was appointed by Shapani attorneys on behalf of the families of Mkhize and others.
Yes, but why does that matter? That's what I'm asking.
The impartiality or otherwise of the report of Stale is being put into question.
But why? He's an expert. He's an expert. I don't understand.
That it was because of the attorneys. It was not by the state. That's how I read.
But that's what I don't understand. An expert is an expert, period. And there are rules of expert evidence. Whether you are called by me or called by my opponent, if you are an expert, you are there to assist the court. So when Mr. Mangena was here, he's not here as Mr. Chauke's witness. He's an expert. He's there to assist the panel.
The prosecutor in me says when an expert is procured by the defense, I'm reluctant to consider it because it's coming from the defense. That's how it happens in practice.
No, I'm not sure I understand. An expert is meant to assist the court. So I bring an expert or you bring an expert, he will assist both of us because
Yes.
he will make concessions where it's fair, but he will be neutral.
Yes, I'm saying you're asking me to comment why the prosecutors are saying that here. No.
So you are trying to interpret what they are saying.
Yes.
No, but I'm asking you, why does it matter?
It doesn't matter.
Okay. Now, then he says in 2012 he was appointed to do reconstructions of some of the crime scenes and is now to be called as the prosecution's witness. Now, of course, the problem here is that they don't mention that Stale was there in 2008 when Mr. Mkhize was killed. All of these experts relied on crime scene photographs, post-mortem photographs, and other statements in the docket. Their evidence should be evaluated against the evidence of the pathologists and ballistics experts that examined the bodies of the deceased and exhibits. I presume that is a fair statement.
It's a fair statement, but it contradicts their conclusion.
Well, the problem is they never engage with it.
Indeed.
You know, they never engage with, these are the findings of Mr. Stale, and this is why they are wrong.
Yes.
Yes. And they are also not telling the truth about what they relied upon, because Mr. Mangena primarily relied on being present at the crime scenes. The idea that they were so distant, they say it was photographs, post-mortem photographs, and other statements in the docket. But Mr. Mangena's evidence was that he visited the crime scenes himself.
Yes.
He didn't just sit in an office and then rely on statements in the docket.
Yes.
And Mr. Mangena's evidence was that he spoke to some of the witnesses. Yes.
And in respect of Stale, he actually attended the physical bodies when the postmortems were being conducted.
Yes. Now then, in paragraph 211, the experts come back again. In Mandini case 7609-2008, the high watermark of statement is that he alleged that the police fired at the suspects when they were already in a lying position. He says that the deceased Mzamani Johannes Nduli death register sustained multiple gunshot wounds. The police officer concerned is not denying that he shot at the accused while they were lying. According to Naidu, as they entered the room, a black male alighted from the cupboard armed with a pistol. Stores fired a shot. Naidu fired several shots towards the suspect. The suspects fell to the floor. The suspect still had the pistol in his hand, and Naidu continued to fire at the male. Now, again, this is just an acceptance of the entire police version, and it's not tested against any logic and against any crime scene reconstruction.
But the summary of that paragraph at the end of it says directly the opposite, that then there is a prima facie case then which the accused must reply to.
I'm saying your conclusion from what they have written is
Yes.
that it simply shows that Naidu should have been charged.
Yes.
Yes, I see. Then the last paragraph where the experts come back to the scene is paragraph 224. And that's the Monday in the case, where it says the ballistic investigation is also incomplete. Several of the cartridges, bullet heads, and fragments found on the crime scene are not linked to any firearms. It appears that the firearms of the police were not seized at the time and sent for ballistic testing and comparison. The ballistic expert Stale, appointed by IPID. Now, was Stale ever appointed by IPID?
Yes, I think in one or two instances, the IPID appointed Mr. Stale as the ballistic expert.
Yes, and then he says the ballistic statement in this case is not complete as none of the shooter's firearms were connected with the cartridge cases and exhibits at the scene.
Yes, Chair, you will remember even when Mangena, or even at Naema, when they testified that when Mr. Steele and Mr. Mangena were doing the presentation before the prosecution team would have preferred and asked Mangena to take over from the Steele, and then Steele was there being instructed, requested by IPED, who were doing investigations.
Yes, but what is the relevance of what they are saying? I mean, it looks like these are just arbitrary and irrelevant assertions made in this report. They bear no resemblance whatsoever to the case that is before them, which is, are these policemen guilty of the crimes that they have been accused with or not?
This is irrelevant, and like I indicated, once you're looking for an excuse not to do something, you'll have to justify it somehow. And unfortunately, this is how it's being done, but it's done poorly.
Yes, and then the one thing which I, in this paragraph 224, is that there's only one sentence that is quoted from the report of Mr. Stale. And so if, according to Advocate Batoi, the only thing she's read is this document. So she will only think that this is the only thing that comes from that statement. But if you go to the actual statement in this Monday, in the case 7609-2008, it is at, what is the page? Where it starts, the report. So yes, the report of Mr. Stale is at MD 0082. Yes, this is what I want.
I'm there, Chair. It's paragraph 6. That's where
Yes.
it's scene investigation.
Yes, thank you. Now, you see, the point here is again a sleight of hand. If you read only this report, you would come to the conclusion that Mr. Stale's evidence is that the firearms of the shooters are not connected to the cartridges found on the scene. That's what you would conclude.
Yes.
Now, if you go to the actual report where the statement appears from, it is at MD 0094. So just go there. MD 0094.
I'm there, Chair.
Because it looks like these authors were doing something more than just recording things that support the NPA. They were also, things that support the police. They were also distorting information. I want to show you what they did here. MD 0094 under paragraph 10. Now that paragraph, it says the ballistic statement in this case is not complete as none of the shortest firearms were connected with the cartridge cases and exhibits at the scene. Okay?
Yes.
Now, if you stop there, you see, if you compare with 224, the last sentence, you know they put a full stop there. Can you see that?
Yes, I see.
Yes. But when you go to the actual document, you know they put a comma and they continue. Right? It says, however, in summary, it appears that two 9mm pistols, one LEW Z88 pistols with erased serial number, and one CZ pistol with serial number G2921 were retrieved from the scene. Now,
Yes.
that information is excluded from the report.
Yeah, that is very unfortunate because it suggests.
But it continues. It then says, this is also depicted on the scene photographs indicating the pistols on the carpet in the vicinity of the deceased. One of these pistols fired 2 shots.
Yes.
None of that actually appears from it. It's deliberately excluded.
Yeah,
Then it continues, however, there were 2 9mm short 9.17mm cartridge, caliber cartridge cases retrieved from the scene where there was no firearm on the scene that could have fired these cartridges. It is also unclear if these 2 cartridge cases come from 1 pistol or 2 different pistols. Furthermore, there is no mention of the exhibits, which I retrieved from the scene and handed over to the Independent Complaints Directorate. Then look at paragraph 11, which again is just not quoted. I mean, based on the information available to me at this time, it is my opinion that deceased Mzamani Johannes Dul, death register 347208, sustained multiple gunshot wounds. There was an entrance and exit gunshot wound to the head, which is consistent with the deceased in a lying position, as depicted in LCRC photographs with an orange striped shirt. I retrieved a 9mm P bullet, which had impacted on the carpet directly underneath the position of the head of the deceased. The exit wound on his head is consistent with the bullet impact mark in the carpet underneath. A further 5.56 caliber fragmented projectile was retrieved from the carpet in the vicinity of the waist of the same deceased as above. Now, what do we know about the 5.56 caliber fragmented projectiles?
Those are the ones that are being carried by the police.
Yes. They come from the R5s.
The R5.
Yes. Then it goes on and on and on and on. It's too long. It goes on and on. But the point is this. In many parts, they ignore the reports. Where they refer to the report, it's just deliberately misleading because it cuts sentences down and then it omits all of the other information that points to the culpability of the police.
Yes.
Yes. Now, we've now dealt with those 2 parts, one on the ballistics. There's one more actually on the ballistics, which is the issue of the residue that I forgot to ask you about. At paragraph 221.
Just a minute, please. Are you okay over there? Is it at the back? Madam? Are you fine? Okay. Yes, thank you.
Sorry, Chair. Sorry, Chair. Can I take a stretch and make a turn at the bathroom?
Too much
You
information.
are absolutely correct, Council. You are absolutely correct. We had anticipated actually that we will adjourn this time. Yes.
Sorry, Madam Chair.
Let's take a 10 minutes break and reconvene.
Thank you, Chair.
Thank you. You are still under oath, Council.
Thank you, Chair.
I see notes right in front of me, Council, about when we are going to adjourn and when we are going to resume. Before Good Friday and after.
Oh.
Someone has been kind to write some notes for me.
Well, giving you the answers or asking the questions?
Would you like us to remind you?
Yes, Madam Chair, that would be appreciated.
The last hearing date, as we had mentioned, will be on Tuesday, the 31st of March. Meaning that we will recess from Wednesday, the 1st of April, until and including Tuesday, the 7th of April, 2026. The hearings will then resume on Wednesday, the 8th. You can remember that, so that whatever you do, you bear that in mind, Advocate Chauke.
Thank you, Madam Chair.
And before I caution the witness, how far are we going to still sit here?
Madam Chair, I think I think yesterday I didn't make an undertaking, but I probably still have another 40 minutes on the analysis of this report. But on Mdluli, I've done most of the work already. I'll probably be another, let's say, hour. So I think maybe then I have an hour and 40 minutes to go in total. Sorry.
In front of me is nobody off record. Somebody very influential is nodding or shaking her head is off record. It's off record. Let me just find out from my sisters. In other words, you'll need something like 1 hour 45 minutes, closer to 2
yes,
hours?
Closer to 2 hours. I think to be realistic, that's what I would need. I'm happy to adjourn now if that's the feeling, but then I will need between 9 and tea time on Monday.
Look, Council, you can finish conferring with your sister.
We are done.
Are you done?
Yeah, thanks.
You heard what Advocate Chauke is saying, that we'll still need about 1 hour 45 minutes to finish with this witness. The plan was to afford you an opportunity to start cross-examining on Monday. Also with the view that his last few witnesses could be squeezed before we retire on Tuesday. Are you opposed to us proceeding? May we still proceed?
Today,
Yes, sir.
to afford
to 7 o'clock.
to afford my colleague
An
that-
opportunity
that-
to finish
with
this witness today.
No, I have no objection to that.
That
have no
will
objection to
enable
that.
you to prepare for cross-examination. And
Even if
By
he were to
weekend?
proceed on Monday, if he were to proceed on Monday, I'm amenable to that suggestion.
yes, the point is, you remember he still has other witnesses who may not even be long, though, but the idea is to have his case being closed when we leave, when we retire on Tuesday. Then when we reconvene in April, you will have an opportunity to proceed with your witnesses. We bear in mind, as we mentioned in chambers, that your period in April is already truncated by these holidays. So we're trying to facilitate finality to afford you ample time. Are you opposed to us proceeding until about 7 o'clock?
I'm not opposed, Madam Chair.
You're not opposed?
No.
Everybody else? We are guided by counsel here. We have a lot of witnesses to finish with, and I think if you can bear with us so that we finish, hopefully, Advocate Chauke,
Yes, Madam Chair.
by 6:45,
Yes.
if we can aim at that.
Yes, thank you, Madam Chair.
If your need arises, we'll take a 5-minute comfort break. Advocate Chauke. I haven't even inquired from you. You are the main person. You've been talking since morning. Are you comfortable that we proceed, or you would rather pause and continue early on Monday? If we decide to proceed on Monday, we may have to start even early.
No, I'm not complaining, Madam Chair. I will have to. You know, actually, today I arrived at 8:10. No one knows this. No one can.
Advocate Chauke, are you comfortable that we proceed until about 7:15?
I'm comfortable, Chair.
Are you comfortable? sir?
Yes.
Yes, thank you. You are the main person here, and your decision guides us. Thank you. Sorry. You may proceed, Counsel.
Thank you.
You are under oath still, sir.
I confirm, Chair. Thank you.
Yes, thank you.
Thank you.
Advocate,
yes.
Chauke, I'm sorry
Yeah,
to
no.
interrupt. Although I'm the one complaining about leaving here late, but I had a question on the last point that you were dealing with, the Mandeni CAS
Yes.
78 of 09/2008.
Yes.
Advocate Chauke, if you can school me here, the first sentence there says the ballistic investigation is also incomplete. Now, I want to understand that, is it incomplete in terms of the documents that have been filed, or it is incomplete because the investigation is still ongoing, especially given that none of the shootist's firearms were taken for ballistics or something, unless if I understand it wrong. But if my understanding is correct that the ballistic investigation is incomplete, then it means this docket is still, or this case is still open.
No, Chair. The ballistic report is complete. That's why before we adjourned, Council took me through the completeness of the investigation of the ballistic report of Mr. Stale. That's why where they write there to say the ballistic officer appointed by IPED also confirms this. He says the ballistic statement in this case is not complete as none of the shooter's firearm were connected with the cartridges, cases, and exhibits at the scene. On the conspicuous of the evidence as you have it there, to do the ballistics test of the shooters in the circumstances where they admitted that they've shot and then the deceased did not shoot at them, there will be no reason for Stale to do any further analysis on that.
You're confusing me further.
Oh,
Because if I go to the docket itself,
yes.
my apologies. If I go to the docket itself, the Forensic Ballistic Services at page MD 0094, at paragraph 10, the last sentence says, once the complete ballistic statement is received, I will add or alter this section of the statement. And then under conclusion, at bullet number 5, it says the ballistic statement is incomplete as it does not refer to the shooter's firearms or the exhibits I handed over to the ICD. And my understanding of the shootist is it refers to, for example, the person who used the 9mm whatever gun, the 9.9 times 17mm caliber cartridge, 5.56 caliber fragmented projectile, and so on and so forth. So the person who prepared this statement says the statement is incomplete as it does not refer to the shooter's firearms or the exhibits that the person handed over to ICD, meaning they haven't received the feedback. So in that regard, my question is the case closed? Can we assume that the docket is closed maybe because of lack of evidence, or we are still investigating? Because my understanding is so there wouldn't be any time period or expiry of time.
Yes, you're right that if the investigation is not complete, then it means a decision will not have been made one way or another, whether to prosecute or not to prosecute.
Thank you.
Thank you.
But I think on the point in relation to paragraph 224, that if you look at the heading in the forensic ballistic report of Mr. Staley, that specifically deals with the ballistic statement.
Yes.
And what they did there, they just captured the first few words in the first sentence of the report itself.
That's what I was referring to, because the conclusions at the end of the statement, the very same statement, the conclusions indicate that the particular findings have been made.
And that's the point that you made earlier upon the questioning by counsel, that this distorts the Stain's report.
Indeed.
Thank you, Madam Chair. Sorry. Just to complete this section, we might as well go to the to the statement of Ms. Shamila Williams, because this is one of the files that she looked into.
So the one on the computer here, it's I see it's 3.
All right. Okay. So, I mean, there's problem number 1, which is the report of these prosecutors, the senior prosecutors, distorts the findings of the ballistics by cutting it in a comma and putting a full stop, whereas the meaning changes as soon as you read after the comma.
Indeed.
That's problem number 1. But problem number 2, this investigation, in fact, was completed as per the statements made by Shamila Williams. If you go to paragraph 140 of her statement, page 42, and she explains exactly what happened in this investigation. Paragraph 140 of the statement, page 42. I'm not sure if there's no effective way of getting.
No. I'm a BBT. There is a problem with the.
Madam Chair, it's actually page 60. 140 is found in page 60. If I may assist my colleague. Sorry. I'm saying paragraph 140, Advocate Ngcukaitobi, is actually found on page 60 of Advocate Batohi's statement.
Why would it be in Advocate Batohi's statement?
I thought you were referring to Advocate Batohi's.
No. Shamila Williams.
Oh, I'm sorry.
Yes.
My apologies.
Okay.
It's actually paragraph 140, page 3-41. Not so, Council? Or which paragraph were you looking at?
Yes, I am looking at paragraph 140.
140.
I'm there, Chair.
Yes. Now, so this is how she explains what happened. So this is the Mandini case 7609/2009.
Yes.
Now, if you compare it with paragraph 224 of the report by the Chauke panel, that's Mandini case 7609/2008. So we're talking about, I think there was a problem with 2009 in an earlier docket, but it was corrected. This is the 2008 docket, because
Yes.
the killing was in September of 2008. Yes. So this is what she explains. On 16 September 2008, Mr. Nzameni Ntuli and Gosnathi Mthembu were shot and killed by members of the Ketumano SVC. So, common cause, it was Ketumano that killed them. The ICD investigator assigned to this case was Ridwan Hafaji. In January 2010, I reopened the ICD investigation into this matter. When I perused the SAPS investigation diary and the documents contained, I identified 2 critical gaps in the investigation. The first was that the firearms discharged by the Ketumano SVC members had not been collected and submitted for ballistics analysis and had not been checked against the IBIS database. Now, that's the problem referred to by Mr. Stale, that I go to the scene and I find cartridges, but the killers have not handed in the weapons. That's the gap.
Yes.
Yes. Now, and then I contacted the Ketumano SVC to inquire about the additional firearms involved in the incident that were not collected when the scene was processed. I was informed that Inspector Mostert's firearm, this is one of Mostert's specials, would need to be uplifted from the SAPS in Rustenburg, as it had been discharged in the shooting that is the subject of the SAPS investigation in Rustenburg, case 109809 2000, and should be 2008. On 17 June 2010, I visited the scene in Mandini to locate and interview the witnesses. That's a different matter too. But the point is this: Mostert has shot different people in Rustenburg and in Mandini.
Yes.
And the firearm is in Rustenburg. It has not been handed in Mandini.
Yes.
That's the problem.
Yes.
And that's why there's a gap between the cartridges and the firearms that have been tested. Yes. Now, this is the explanation with this.
Yes.
Then if you go further to paragraph 148, Now, you will recall that when we read the statement of Mr. Stale, he was puzzled by this idea that he found a 5.56 millimeter cartridge without the firearm. Now, that puzzlement is resolved by paragraph 148 of Ms. Shamila's Williams' statement. In or about 10 June 2010, I obtained the missing firearms from the Rustenburg SAPS. I collected one R5 rifle with serial number 347921 ICD 12297 and one Z88 pistol. You remember the specialist of the Z88?
Yes.
Who is that?
Mustard.
Yes. With serial number Q119840 ICD 22615, together with one R5 cartridge and one R5 bullet head ICD 12297. Len John and I requested ballistics analysis of the additional firearms and the additional cartridge cases and bullets. Now, this is the whole point, is that if you read, this is where this report really is problematic. If you read both statements of, this statement I'm dealing with now is also contained in that docket, in the Mandini docket of Ms. Williams. That the one investigator says there is a problem that I'm collecting cartridges of a Z88 and an R5, but I can't find these weapons. And then Ms. Williams says, no, I want to find the weapons. That therefore concludes the investigation. Now, you then get a report like this, paragraph 224. I mean, this is gravely misleading, isn't it?
Indeed, yes.
Yes. Because no one refers to the statements made by Ms. Shamila Williams, who says, no, the problem was that these people shot someone in Mandin and in Rustenburg.
In Rustenburg.
Yes, and the weapons were there in Rustenburg, being tested that side. And that's why at the time of the completion of the first report, these weapons could not be linked to the cartridges.
Yes.
But then she says, I sorted that out. I found the rifles.
Yes.
Yes. But you would expect, Mr. Chauke, wouldn't you, that in 2019, when these prosecutors are sitting around the table, they will do precisely what we've done, which is, if somebody says, I've looked at the statement, it's got something missing, you look somewhere else in the docket to see whether it can be found. And then that's where the answer is.
Yes.
Yes.
That is to be expected. A thorough evaluation of, especially where you are reviewing a decision that would have been made earlier on, you will be as thorough as doing the comparisons of all the statements of what is contained in the docket.
Because the problem is that they leave you with the impression in paragraph 224 that the ballistic investigation is incomplete.
Yes.
You know. And therefore you would think that the people who did this case, the policemen and your team, were incompetent because they didn't make sure that everything is in the docket.
Yes.
But that's simply because the reader hasn't done their job.
Not that they did not do their job.
Okay.
They did their job to mislead.
Well, yes, the reader has produced a misleading report.
Yes.
Yes, thank you. So that's the answer, Advocate Baloimer.
Sorry. When I looked at everybody earlier about whether we should proceed, I did not recognize the NPA. Advocate Lekgetho, I suppose you are fine with the arrangements. And also members of our team from Harris Molebatsi attorneys. And I meant no disrespect to you. And of course, all the journalists. Yes, thank you.
Is everyone happy to well, everyone is proceeding, whether they're happy or not.
But of course, it is the respect that you accord them.
Yes. Okay, thank you, Madam Chair. Look, if you ask me, I would have preferred to adjourn, but anyway, I'm now here. My colleagues point me to another error that I hadn't picked up, but they picked up, which is in paragraph 225.
I'm there, Chair.
Yes. Now, so it says in some of the dockets, there are mistakes in some of the ballistics reports, and some reports are not filed in the docket, okay? So let's focus on the part which says that reports are not filed. In Mandini, case 76, it is stated that the report that the cartridge cases mentioned in 3.1 were fired from one firearm. This is a typographical mistake in the ballistics report and should be corrected. 3.1 refers to a firearm 9mm parabellum, caliber Lu models Z88 semi-automatic pistol with serial number obliterated and not cartridge. Now, why would a prosecutor be worried on their own version with a typographical mistake?
I'm surprised.
Yes. Now, then they explain another part, which would be more serious, where there is a report that has not been included in the docket. And then they say in Durban Central, case 185-02-2009, the ballistic report with reference number LAB 185920905 was not found. All right. So that would be material, would it not be, that there is a report that's not found?
Yes.
Now, when we go to that docket, which is 185, you remember that's a big one. It's got lots and lots of documents. And we then try and find it. All right, just give me the number of the docket. No, but what's the number, the page? No? So is this is DC? So, Madam Chair, it is DC 451 up to DC 454. Just give me that. Yes, I think it is DC 000451. Yes, it's correct. It's correct. Yeah, it's correct. Now, have you got DC 000451?
Yes.
Now, the yes. Now there is. The numbering is actually clearer on DC. On DC 000452, which is the following page.
I'm there, Chair.
Yes. Now there it says LAB 18592/09, and then it says bracket 6.
Yes.
And then, so that's clearer. Then if you go up, this is an affidavit, so because the number at the top there is a little bit obscure. The name seems to be Solomon Nkcukaitobi Modisane, who is a warrant officer in the ballistic section, employed as a forensic analyst. Can you see that?
I mean, the deponent of the statement.
Yes, that's the name of the deponent of the statement. But the point is that this is a man from the ballistic section of the police.
Warrant officer, I think Solomon Nkcukaitobi Modisane.
Yes, exactly. But if you look at where he comes from, he's a warrant officer employed as a forensic analyst, but he's attached to the ballistic section
Yes, Silverton, forensic analyst with address Pretoria Road, Silverton.
And then he provides this.
Is first number.
Yes, he provides this ballistics report, which ends at DC 000454 on the 27th of March 2012.
Yes.
So I come back then to this report. That the impression you would get, therefore, is that there is no reference to the ballistics report that is there from the forensic analysis section. Sorry. So the impression you would get, therefore, if you go back to paragraph 225, is that there is no ballistic report. In other words, they don't say, well, we've got a ballistic report from Mr. Modisane. If they are saying there are flaws with it, then they must say there are flaws with it. But you get the impression that there is no ballistic report.
Yes.
You see what I mean? Because this is, if you look at where the sentence starts, in some of the dockets there are mistakes in some of the ballistics reports, and in some of the ballistics reports are not filed in the docket.
Which is incorrect.
Yes. Now, you would expect then that somebody would say, but I've seen a ballistics report from Mr. S.K. Modisane. It says the following.
But Chair, in respect of this specific ballistic report, that sentence that says in Durban case 185/2/2000, the ballistic report with reference LAB 18592 in brackets 5 was not found. Then the one that we opened here is 185290 in brackets 6.
Yes, no, I say that. The difference is the 5 and the 6. But
Yes.
the point I'm making is this. If you look at the beginning of the report, you think that when you read the report, if that's the only thing you've read, that there is in fact no ballistics report.
Exactly, because the next sentence there says, in the same docket there appears to be mistakes in the reports.
Yes.
So you can't have mistakes in the reports which you say it could not be found.
Yes. So what you would expect, if you are fairly analyzing the docket, you would say, look, I'm missing report 6, if you are talking about report 6, but I've got report 5.
Yes.
That is a ballistics report.
Yes.
You see.
In this context, it will say we did not find a ballistic report 6. We found ballistic 5.
Yes.
We found ballistic 6.
Yes. And then you say this is what it says.
Yes.
Yes. But if you are like Advocate Batoyi, the only thing you've read is this. You'd think, okay, well, there are no ballistics reports here.
Indeed.
Yes.
But still, Council, even in relation to that 6, it is clear that it relates to the Durban Central Case 185/2/2009.
Yes.
We know that it is 2008.
Yes.
Am I correct, Council?
Yes, yes.
So
Because the death
they
is September.
say there that in relation to this Durban Central, the ballistic report was not found, this number 5.
Yes.
But where is mention made in respect of number 6? Because it is there.
Yes, that's the point I was making, to say if they say they did not find the in brackets 5, the in brackets 6 is there.
At least they must make mention of bracket
Yes,
6.
because they say the last sentence, in the same docket, there appears to be mistakes in the reports, which according to them, they did not find. In the same docket, a second set of bullets from the mortuary are missing.
Yes, but where are those from?
It can be on the reading, when we read there to say the report could not be found. You cannot say in the same breath says there are mistakes in the reports.
Yes. It then goes further. If you then look at 226, They say in some of the dockets, either the firearms found in possession of the deceased had a serial number, or in the case of obliterated serial numbers, some of the numbers were retrieved through the etching process. Okay. Now, this again is another sleight of hand. They are saying already that these are firearms found in the possession of the deceased.
Yes.
Now, where is the version that actually these firearms were not found in the possession of the deceased? They were found in the possession of the shooters.
It does not appear from that paragraph. On the Kuzara reading, there, it doesn't show that.
Yes, but this is a blanket acceptance of the version of the police who have shot these people, and they've said, we found these firearms.
My point exactly.
Yes. Then it says, no investigation was done to determine ownership of how the firearm possibly came in possession of the deceased. But the person who brought the firearm is the shooter. So where should the investigation have taken place?
It's accepted that the firearm was with the deceased.
Yes, but
in this narrative.
Yes, but where you know that there are at least 3 witnesses who have said it is the police that planted these firearms. The person to be investigated, would it be the deceased or would it be the police?
On the evidence as we have it, it will be the police. My problem is they don't say in this docket, this is you see the opening line there. It's somehow problematic because it says in some of the dockets, either firearms, and then the example that it's made on the bottom there, in Mandeni, which we have just looked, the second firearm with that serial number was stolen at a police station from subs safe 13 and appears to be one of several that went missing from that police station. From that police station, Ulundi, no suspects were identified. It therefore begs the question how the state is going to prove that the accused planted this firearm.
But just explain that to me. A firearm goes missing from a police station.
Yes.
Who has access to a police station?
It's the police.
Yes. And the case that is being made by the NPA is that some of these firearms are used in the commission of offenses by the police.
Yes.
So why then would they come to the conclusion that you wouldn't be able to prove that the state, that the accused planted the firearm?
Well, on the face of it, that is easy to prove because the firearm is there in the seat.
And they can trace it back to the police station?
Indeed.
Yes. Now, before we took the adjournment, I had wanted to take you to paragraph 221 on the different topic of residue tests.
Sorry.
That is in the
In
Chauke report.
Advocate Chauke's report, yes.
Before you go there, in this memo, the Chauke memo, a number of shortcomings were identified in terms of the analysis of these cases. But and in most instances, we can see that not all the information was included. So some of the information was maybe deliberately or inadvertently excluded. But in instances where the team identified that there was supposed to be a ballistic report and it is not there, and that's the first instance. In the second instance, there are mistakes in the docket and in the reports, things that can be corrected. Shouldn't they have sent back the dockets to the prosecution team to correct and deal with the issues and go forward, sort of maybe reviewing or overseeing the prosecution team? Or was it the correct procedure to follow to just withdraw or drop the charges because there are mistakes and there are things that can be easily corrected?
Now, they could have sat with the prosecution team. They could have called their colleagues to say, look, we are here, we have got this particular problem, because this is not even a problem. What has been characterized there is not accurate.
Thank you.
Yes. Yes, I suppose, I mean, it doesn't even have to be a technical report like a ballistic that contains technical errors that are obscure from the naked eye.
Indeed.
Even an ordinary lay witness can make a mistake in a statement.
Indeed.
Do you then say, I have no case because the lay witness has made mistakes in the statement?
No, not really. That's why I'm saying if they have discovered this and there was a consultation with the prosecution team, they would have got an explanation how those things came about and how they could be overcome without making a meal out of that.
Yes. So then we just deal with then the Howick case. You know, somewhere else in the report, they say in several instances, primer residue was found in the hands of the deceased. They say several. Then you try and find in the report, where is this several? You then come to one paragraph that talks about one instance, which is this one of Howick.
Yes.
Paragraph 221. Now, if you remember the story of Howick, now this is the story of Mr. Magoja on demand.
And his bodyguard Tembe.
And Mr. Tembe.
Yes.
And you remember how ruthless they were executed.
Yes.
And one of the statements by the police, Mr. Mostert was there. Mr. Mostert used a shotgun, Z88. The police admitted that Mr. Tembe was shot while he was running away.
Yes.
And they never alleged that Mr. Ndimande, who was driving the vehicle, pulled a gun.
Yes.
At the time that they shot, from the statements that we analyzed. Now look at what they say here in this case, Howick case 106/08/2000. Residue tests were done on the hands of the deceased and police officials. Primer residue was found on the test sample marked inter alia B638 right. There is a statement from Zondi that simply stated that he collected 11 spent cartridges, 86 live rounds, 5 rifles, 3 pistols, 5 magazines, and he produced primer residue test results on 2 deceased and on the policemen involved. It is not clear on whose hands the primer residue was found and why, if several police officers admitted that they shot, he took primer residue on the hands of one police officer. Now, just reading this, I couldn't work out why does this matter. It's common cause there that those 2 gentlemen were killed by the police, and it's also common cause which of the bullets were the fatal ones.
But it's irrelevant.
Yes.
To the extent that the allegation of the police is that there is a residue in one of the deceased. Why must you investigate that? And then you say it's incomplete. Why the other policemen's hands were not tested for residue? Why do you test them when they said they have shot?
No. You see, it's worse than that. They don't say that there was primer residue in the deceased. No. They say it is not clear in whose hands the primer residue was found. So this is not even a case where they say the primer residue proves that the deceased was trying to shoot. No. They say we tested the corpse and tested the deceased and we found primer residue, and we can't work out in whose hands the primer residue was.
My point is, even if you do not know in whose hands the primary residue was, on the facts of what we now know and the explanation from the police, the residue, whether it's from the 2 deceased or from the police, I'm saying it doesn't matter. Because on the evidence, what the statements that we referred to, they shot the deceased when the deceased was running.
Yes. No, but I mean, you see, the whole thing of the primary residue, which is the point the evidence leaders tried to make with Mr. Mangena, you remember, was that, well, the primary residue, in fact, not just the evidence leaders, it was also Advocate Nasir Kasim, said, look at the primary residue. The primary residue showed that you are shooting. But this is not a case here where the primary residue is found in the hands of the deceased. This is a case where it's unclear on whose hands the primary residue is. Why would that be a reason not to proceed with the charge?
No, it's irrelevant. That's what I'm saying. It's to find an excuse to do a whitewash. It can.
Yes.
That's what I'm saying. Even if there was a residue on the hand of, take it further on the hand of the deceased, you needed to determine whether indeed the deceased shot at the police, because the presence of a residue on the hand of the deceased does not necessarily follow that he fired the shot.
Yes. And then the same thing they make in Mandeni, the case we've just looked at. And then they say, paragraph 222, it is not clear from the evidence in the docket on whose hands the primary residue were found. And then they talk about two boxes where the primary residue tested positive, and then there is no report from the LCRC. Now, again, where it's admitted that the police shot the deceased, and then you say, well, on the evidence, I can't work out where the primary residue comes from. What's the relevance of that?
It's irrelevant. That's what I'm saying. If a policeman said, I'm the one who shot at the deceased, why do you have to prove that his firearm is the one that shot the deceased when the policeman himself says?
Yes. Right. So we've now done a lot of, most of the evidential and methodological flaws in what the Chauke panel did. Do you think some of these could have easily been resolved had they not just spoken to the prosecution team, but spoken maybe to the investigators?
Either way, whether they could have spoken to the investigation team or they could have spoken to the prosecution team, this would have been clarified, simply clarified.
Yes. Then you have another section then that I need you to deal with, because it looks like it's an overarching section on racketeering. We dealt with all of the legal problems of racketeering with Advocate Mayema. I'm not going to ask you about those because I've been spending time with you just on the facts. Yes. This is at page 82 of the report, paragraph 212, under the heading Lack of Proper Investigation, subheading Racketeering Offences. So then they say here, it is evident after the analysis of the dockets that there were serious concerns regarding the quality of the investigation into the racketeering offences and the underlying predicate offences. Investigations of this nature ordinarily take more than 5 months to be finalized. Now, let's just stop there. Now, what is the relevance of the fact that racketeering investigations usually take more than 5 months? If you finish it in a month, what's the problem?
There's no problem at all. If you read further, you'll see that it's trying to come with a justification which is untenable.
Yes, but in this particular one, we know that this investigation began in January 2012 when General Mabula was asked by General Dramat after the newspaper report to go to KZN and constitute a team of investigators. We also know that the indictment was finalized only in August, which would therefore meet their period of 5 months, because this was done in 8 months.
Yes. If you look at that 5 months, Chair, the arrests were done in June.
Yes.
So that 5 months is intended to describe that arrest of June.
Yes, but they were not arrested in June. That's where there is a slight offense again. In June, they were not arrested for racketeering.
No, I hear you, but I'm saying if one reads this in accordance with what would have actually happened, the suspects, firstly, when they were arrested for the general offences of murder and related offences was in June. So if you calculate from January to June, that is where the 5 months is coming from.
Well, that's still 6 months. That's still more than 5 months. In fact, the investigation here began in December 2011.
No, I'm accepting that it started in January. Like you're giving an example about General Mabula.
Yes.
In January to June. That's how I see the 5 months trying to speak to that.
But why would you, as the NPA, criticize a prosecutor for investigating a case over 6 months? I just don't understand what the problem is.
When he should comment that the investigation was done as quickly as possible.
No, but their point is that investigations of this nature generally take more than 5 months to be finalized. But yours took 8 months to be finalized.
Yes.
So it's more than 5 months. So what's the problem?
It's fluffing.
Then they say in cases of
Are
this
you
nature.
saying it should actually be commendable
Yes.
because it shows thoroughness?
Yes.
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 Yes, that's what I was referring to, Chair.
Yes.
That the more time you take to consider these things, the better, because at least we now know that a thorough investigation has been done.
Yes. And they say in cases of this nature, a racketeering docket will be registered. That will document the investigation. This did not happen in this case. There is consequently no investigation done that shows how this case was investigated. There is thus no objective record of the investigation. What is your answer to this?
Completely hogwash. There's no way where you go to the police station and go and open a racketeering docket. There's nothing like that. There is just nothing like that. Racketeering is determined because you look at predicated offenses and then look at patterns and then you determine as a prosecutor that there is racketeering.
Yes.
No, a policeman is not going to sit at the police station and then he says, this is racketeering docket. There's nothing like that.
Yes, yes. Because racketeering is a conclusion of law
Yes,
based on the predicate offenses
Yes.
and the other elements.
indeed.
Yes. So now you've got 23, you can see the patterns, and you describe that as racketeering.
Yes.
And as you say, that there's no policeman sitting at a police station who's going to open a docket of racketeering.
Never.
Where do they get this from, this idea? Because they don't even reference their source. They just assert this as their own conclusion.
I don't know. I can suspect, like I'm saying, once you do things to want to reach a particular conclusion, you'll do some of these things.
Yes.
Should we assume that they did not know what they were doing?
Yeah, I happen to know closely 3 of the members of that prosecution team, except one who's based in Cape Town. But the one, unfortunately, may his soul rest in peace, Mama Bulo. I think he's the one who drafted this thing.
Meaning he did not know anything
Nah.
about racketeering.
Yeah.
Yes.
Did he sign? Did he sign this report?
Yes, Madam Chair. You have got the 2 reports where him and Advocate Chauke signed. And then you have got the other one where only Advocate Chauke signed.
Yes. Well, I mean, you would expect in something like this that they would produce something like a racketeering manual, or a racketeering policy, that you can reference and say, this is how it's done. You can't just thumbsuck and just put a sentence like this.
Of course.
Yes. Then they say, in the Danica statement, the allegation is that the criminal enterprise has been in operation for a longer period than what is alleged in the indictment. If the purpose of a racketeering investigation is to look at the life and continuity of the criminal enterprise and how it evolved over a period, the allegations in the Danica statement and corroboration thereof should have been fully investigated, which has not been done at all. I don't understand what this means.
No, it's a lack of experience of the drafter.
Yes.
Yes.
But I mean, what does it mean that you have not corroborated the allegations contained in the Danica statement? One of the allegations he makes, just as a common example, is the Berea case.
Yes.
There is a full Berea case docket
Yes.
with full witness statements, including an admission by Mr. Mostert that he shot at the gentleman
Yes.
and the other policemen that were on the floor when he landed from the fourth floor
Yes.
and continued to shoot him.
Yes. So it couldn't be that you can come with that kind of a statement with reference to Danikas. It just is untenable.
Yes. Then they say this once again shows that there was a haste to obtain the racketeering authorizations since an investigation focused on the life and continuity of the criminal enterprise should have been done over a long period. It's unclear what this means. It's either it means you should have delayed your investigation, you should not have finished it in 8 months, should have done it over 1 year maybe, over 2 years, I don't understand.
No, but apart from that, that statement alone indicates that the draft of the statement does not even understand what Chauke and the enterprise and the life of enterprise is all about.
Yes.
That's what it shows.
Yes. I mean, the other thing about this sentence is that if you read Chauke, one of these objects is to enable the police to disrupt the enterprise.
Yes.
So I don't understand what they mean that you should take longer to investigate the enterprise, because if you take longer to investigate the enterprise, rather than achieving the goal of disrupting the enterprise, you actually achieve the opposite of enabling it, because you are just watching them committing crimes and just waiting for, I don't know, a time to lapse, an arbitrary time to lapse.
Indeed. If you are able to determine the tearing patterns, even in a month or 2 months, you should be in a position to act decisively to disrupt or to stop it. The reason why it will take longer is because you are unable to pin the role players and whatever. That's what takes long. But if in a month or 2 or 3 you are able to pin them together and there will be no reason for you to take long to disrupt that enterprise.
Yes.
Let me just verify this, knowing how difficult it is to investigate, for instance, white-collar crime,
Yes.
which is also part of the racketeerings. Sometimes it takes longer because those concerned know how to hide.
Yes.
And it becomes very difficult to trace them.
Yes.
Or to trace the money, for instance.
Yes.
So you try to connect the dots. The connection of the dots becomes sometimes a bit difficult.
And even tedious.
And it takes a longer time.
Yes.
So it can also happen that it takes a longer time to come to the crux of, or the conclusion of the investigation.
Especially where especially in this case where you're investigating those who are supposed to investigate.
Yes.
It will not be easy for you to get into that space.
Yes.
Yes.
Thank you.
I had a question. At paragraph 212 and towards the end of 213, are we still talking about the same thing, racketeering? Advocate Chauke?
Yes, that's from the report as I read it. That's what, because even the heading says racketeering offences.
So help me understand this. Investigations of this nature ordinarily take more than 5 months to be finalized. And then they go on and say, this once again shows that there was a haste to obtain racketeering authorization since an investigation focuses on the life and continuity of the criminal enterprise should have been done over a long period. And from your answer, when you were dealing with 212, you said it took almost 6 months, which was more than 5 months.
Yes, I was explaining when I was asked about what is the relevance of
5 months.
Of 5 months.
And now the team is now being blamed, or that they were in haste to obtain the racketeering authorization, since the investigation should focus on the life and continuity of the criminal enterprise. And my question is, is it really impossible to crack a racketeering case within a shorter period?
Not at all. It's possible. That's why I was giving an example that if in 2 or 3 months you are able to crack and disrupt the enterprise and the like, that should be commendable. But
And-
unfortunately, in most cases, it's not it's a complex investigations that need to be done around those issues.
But let's come to this specific case in point, where there is a pattern
Yes.
building over a number of years, and you come in maybe say on the 3rd or 4th year, and you go through the dockets, you would be able to establish that pattern within an even shorter period, and maybe establish a racketeering principle within a very short period based on the information that you have at hand.
Yes.
In that instance, would it be fair to put a blame on a team that delivered before the even expected time?
No, in fact, you need to commend the people. Remember, these incidents happened from 2007, 2008, the dockets have been opened. Now, when the so-called investigation will start in 2012, already the incidents have happened, people have been killed. Now, all that you needed to do is to look at the instances, look at the pattern, take all the dockets, the 100 of them, 53 like they indicated, and out of the 53, and then we realized this other one said 27, we might have problems. With this 23, the pattern is that, and then we develop the racketeering, and then you indicate the similarities, similar facts, and whatever, identify who are the actors, identify that. That should not even take you, that should not even take you 3 months. That's why the prosecution team were able, when they were doing these things within 3-4 months, to be able to determine that there is this racketeering that is happening in this instance.
Thank you.
Maybe just to follow up on what my sister has said. When one looks at I'll just give the references. The summary that was written by Advocate Mosing, that appears on LO 706 to 707. In particular, at paragraph 7.
Sorry, Chair, page?
00706. LO, ne?
706.
Yeah, 706, thank you.
I'm there, Chair.
Yes. Now, when one looks at right towards the middle, you know, there's a sentence that starts with Hawks had a joint meeting with the minister a week ago. You see that, Hawks, where the sentence starts with Hawks?
Yes, Hawks had a joint
Yeah.
meeting with the minister a week ago,
Yeah, and can you just read that?
whereby the minister expressed his dissatisfaction with the slow progress made by the 2 investigating units, since it had been pending since December 2011. It was apparently decided during that meeting that the 2 units should conduct the matter jointly, and that had been working throughout the previous weekend.
Thank you.
The-
Yeah. I'm just highlighting this also to show, according to what we have on record, that already this issue had already become a pain even to the country, because if the executive speaks, it means it's urgent.
It's urgent.
Now, the authors of this report are suggesting that this thing ought not to have been finalized or dealt with, or to have progressed to the point at which it was. The expectation was that it should be approved at snail speed.
Yes, and the importance and the outcry that was out there from the community, and it looks like it's being overlooked here.
And it is my understanding, it's a common understanding that the NPA is independent.
Yes.
But in that independence, when the executive authority speaks about the concern of the public, the NPA is expected to rise and address the outcry.
The NPA is independent in terms of prosecutorial function for them to decide cases and the like. But in terms of the public perceptions and what the public expects, the executive authority will always prevail that the community has got this problem. Can you? What is it that you're doing about this thing?
While independent, it is there for the people, not for itself. Thank you.
The independence cannot be used to be legalistic instead of doing your job.
Right, thank you.
Thank you. Mr. Chauke, I wanted to follow up on something that Commissioner Baloyi Mere was raising, which is that there was something unique in the case, in a sense, because there were already existing dockets. It was not your typical racketeering, where there is a criminal enterprise selling drugs in Cape Town or in KZN or in Johannesburg, where you are blank.
Yes.
So this was a different criminal enterprise, because these dockets had been opened for a long period of time, but they had gathered dust. And so what impact did that have on the expedition in relation to this? I think that's the crucial distinguishing feature here.
Yes. Once you want to investigate the enterprise and the like, remember you start with doing getting the Section 252 authorization for listening devices, traps, and all sort of things for you to be able to link the different stakeholders in the enterprise. But where already the offenses have been committed in a pattern, you don't need that long that long reasoning to say, oh, here 100 people have been killed. I now must go and start investigating to see whether this. You look at the patterns. You look at people have been killed. The modus operandi is just exactly the same, and then you get to know that the purpose, the reason for justifications of this is because of this and this and this and that, and then you look at the pattern. Yes. Then you get people who were part of those killings who are saying no, who were there, like Danica saying, no, look, I saw. This is the pattern, and they're like, what more do you need?
Now, then, just on this question that has been raised by Madam Ramachar, it's been raised in different contexts that Minister Natim Tetwa intervened and said, get on with it. On the one side, there's a moment at which he says, you guys are too fragmented. You must work cohesively. And then he destroys the boundary at that point, the investigative boundary between the SAPS investigators and the IPID investigators. And then he asks for reports, and you give those reports on a regular basis.
Yes.
So the context in which this is used is, well, look at yourselves. You are being told by politicians what to do. The other context is what Madam Ramachar is saying, which is the NPA is not an island. It is ultimately accountable to the people.
We're still, Chair, you have a situation where many people have been killed. It's apparent that IPID does not have capacity to investigate those police in this context.
Yes.
It's obvious. So once you sit there as a responsible principal. And then we realized that these guys, they actually do not have capacity at all. And then there are these ones who have got the capacity, who can be joined together to do investigations and the like. That's the obvious thing to do.
Yes. And that can be done without dictating the
Operational
direction
whatever, yes.
of the investigation. You
Yes.
still maintain your independence.
Yes.
But what he was doing, I mean, this is where the whole thing sometimes loses sense. He was not telling the NPA what to do. He was getting the operations of the IPID and the SAPS to work in sync.
Yeah, in fact, the minister with reference here is the Minister of Police,
Yes.
calling the iPad and the DPCI, the Hawks, together to say, look, guys, you must go and investigate these things. This silo that this one is investigating that, and that we have now realized that as iPad, there's no capacity. I need to get the DPCI to join you to investigate. The DPCI, that is part of Katomania, because Katomania, they're also DPCI. But you get the DPCI from another province to help the IPAD to investigate the DPCI in KZN. In essence, this is what has happened.
Yes. And now on this issue around interference with the NPA, I mean, you attended some meetings there with the minister, or did you attend meetings with the minister?
I attended the meeting with the Minister of Justice, with Advocate Chauke. She needed to brief the minister,
one
because
meeting.
there was a question, concern in Parliament as well, to say this is what is happening and what is the NPA doing and whatever. So the minister, in that sense, needed to understand what is the case all about. And the only way he can understand is him being briefed.
And that was the Minister of Justice.
Yes, Mr. Jeff Kadebe.
Yes. And then you didn't attend meetings with the Minister of Police.
No.
Yes. Now, under the Constitution, Section 179, isn't the NPA answerable to the Minister of Justice?
Indeed.
Yes.
And then even in terms of the NPA Act, Section 34, I think the Minister of Justice may from time to time ask reports from the NDPP relating to a specific case where there are concerns, where there's an outcry and
Yes.
yes.
It looks like someone has found the section in the Constitution. I think there's a section that says the minister exercises overall responsibility. Yes, Section 179, subsection 6. Do you have the Constitution?
I have the similar provision in the NPA Act, which will be Section 33. But yeah, Section 7.
This one is Section 179, subsection 6. What does
I'm
it
there,
say?
Chair.
Yes, what does it
The
say?
cabinet member responsible for the administration of justice must exercise final responsibility over the prosecuting authority.
And you say then, you also want to refer to Section 33 of the NPA Act,
Yes.
which says,
The minister shall, for the purposes of Section 179 of the Constitution, this Act or any other law concerning the prosecuting authority, exercise final responsibility over the prosecuting authority in accordance with the provisions of this Act. To enable the minister to exercise his or final responsibility over the prosecuting authority, as contemplated under Section 179 of the Constitution, the National Director shall, at the request of the minister, furnish the minister with information or a report with regard to any case, matter, or subject dealt with by the National Director or a director in the exercise of their powers, the carrying out of their duties and the performance of their functions. Provide the minister with reasons for any decision taken by a director in the exercise of his or her powers, the carrying out of his or her duties, or the performance of his or her functions. Furnish the minister with information with regard to the prosecution policy referred to in Section 21, subsection 1A. Furnish the minister with information with regard to the policy directives referred to in Section 21, subsection 1B. Submit the reports contemplated in Section 34 to the minister, and arrange meetings between the minister and members of the prosecuting authority.
Yes, thank you. So it seems explicit that the minister is entitled to ask for reports in relation to a specific case.
Indeed.
So if he says, I want a report on the Keitomano case, it's not as if you have an option. The Parliament has said you must give the report, otherwise you will be breaching your own statutory obligations.
Indeed. The minister's responsibility it's defined in the Constitution and in the NPA Act.
Yes.
Just to complete it, little portion. From where Advocate Chauke had ended, it explains the reason why this meeting and the proposal for a joint effort to try to deal with this matter that was burning and that had been outstanding for some time. It says the reason they came to see the acting NDPP was that they needed to rope in prosecutors to handle the matter urgently, and that the prosecutors seemingly promised by acting DPP of KZN, Advocate Molochwa, was not materializing.
Yes.
So that's what created the need, according to the explanation of Advocate Musing.
Yes.
Do you agree with this assertion?
I agree to the extent I have got no veracity of what Advocate Musing is saying, but on the proper reading and understanding of what was happening then, that made a proper sense that should happen and be done as quickly as possible, because there was an outcry in the public there. This thing was in the front pages of the Sunday Times.
And it is correct that the acting National Director of Public Prosecutions referred to herein was Advocate Jiba.
Indeed.
Thank you.
Yes. So when you say you can't vouch for the veracity, were you not aware that there was a problem of lack of prosecutors emanating from KZN in your role as coordinator?
At the time, I'm referring at the time when there were discussions about the prosecutors and what, because I was only phoned to say, there is a problem. We need prosecutors that must.
Oh, I see. You came after these discussions.
Yes.
I see. But it was also the same explanation you got. Why should Johannesburg go and assist in KZN?
Indeed.
Yes. And what was the reason?
The prosecutors in KZN, most of them they might have conflict of interest and not and impartiality, because they have worked in the main with the officers of Katomani, both from the prosecutors and in the DPP's office.
Yes, I mean, but what we also know from the evidence of Ms. Shamila Williams is that these cases had been reported for prosecution as individuated offenses.
Yes.
Like murder, torture, and all of those.
Yes.
Since 2007.
Yes.
2008, 2009, 2010, 2011.
Yes.
But they were not being prosecuted. Instead, senior prosecutors in Advocate Batoi's office were diverting them to inquests.
Yes.
And sometimes issuing nolle prosequis even after the inquests.
Yes. And Advocate Batoi, as the DPP then, would have known about all these cases until 2009 when she left.
Yes.
Yes.
She would have. I mean, she gave evidence here that she was away for 10 years and then she came back and she discovered this, but I think that was contradicted by the facts.
What was your answer?
I'm saying that she was not around is misleading, because she was the DPP from 2002 until 2009. But in terms of the NPA record, she was actually from the DPP from 2002 until 2010.
Meaning most of these things happened while she was in office.
In office in KZN.
Thank you. All right. I think we've covered those. Those were the questions from the bench. Can we then go back to the racketeering analysis contained in the report? We've dealt with 212 and 213, and then in 214 there is a racketeering investigation focuses on the entire enterprise rather than individual participants in specific criminal acts, which appears was the focus in this matter. Now, how do you answer this? They say, well, you focused on the individuals. You should have focused on the enterprise. I mean, sometimes I don't understand what that means if you look at the case like Bess versus Ayer.
Yeah, but for you to identify an enterprise, you can identify it through individuals.
Yes.
Yes.
Because
So
the enterprise is a collection of the
It's a
individuals.
collection of various individuals. At times, an enterprise can be a one depending on the nature and the facts of a particular case. Yes.
So this is also a legal misdirection.
Of course.
Yes. Then they say, consequently, there were no investigations to determine the nature, structure, and scope of the enterprise, as well as the relationships of the members of the enterprise. Okay, I mean, I know you said there's a misdirection of law, that they think that an enterprise exists in an abstract, but an enterprise is a collection of individuals. But they make a different criticism, it seems to me, that there was no investigation to determine the nature, structure, and scope of the enterprise, as well as the relationship. I would imagine those are relationships inter se among the operators. Who's the boss? You know, who's the guy that hides the firearms? Who's the guy that collects the bodies, etc. So you didn't investigate. Well, the team didn't investigate that.
But what was there to be investigated when we know that it's Katomania? The boss of Katomania is the Major General Johan Boysen. What further were you supposed to investigate?
I mean, I suppose they could say, I suppose it's whether they are operating, because your point is that they are a formal unit, but they are committing crimes.
Yes.
They are a formal lawful unit, but they're committing crimes.
Yes.
And so to that extent, and it's all common cause, by the way, that they shot people.
Yes.
The question is whether those shootings were criminal in nature or justified.
Yeah.
Yes.
Whether they were justified or not justified.
Yes. But what would you would still need to characterize the conduct.
Indeed.
So there would still be some work to be done to characterize it.
As the prosecutors will have to look at all its predicate officers, all the killings to determine whether there is a particular fashion or a particular conduct. And then from there, determine what is the purpose for these killings, because that also is central to see the pattern and the motive and what is killing. And that's why, in this instance, the prosecution investigation, with the investigation team, they were able to determine that some is motivated by for monetary and for self-gratification in terms of who shoots best than who.
Yes, I wondered about that requirement of a motive, because it does not appear to be a requirement in the definition.
Yes, I'm saying once you want to satisfy yourself about the operation of an enterprise, you look at all angles and see what could be the reason that people act in this fashion, in this particular fashion.
Yes, but I mean, if you removed that motive in your analysis, the point I'm making is that under the Act, you still have a racket.
Indeed.
If you can satisfy all of the elements, this idea that there must have been a financial reward, etc., is not actually required in the Act.
No.
Yes.
No.
It just happened incidentally that sometimes they were paid by the taxi association, sometimes they paid themselves from the monies that were collected through the internal systems.
Yes.
And then sometimes, as Mr. Danica said, they got freebies in hotels, and then sometimes they took properties of people that they killed.
Yes.
Television sets, and those things would just disappear.
Yes.
Yes. Then they continue to say, this explains the lack of cellular phone evidence and an analysis thereof to show a pattern of communication between the members. Now, what do you say to this, that you can't show that these members were communicating?
It's irrelevant. Show what? They are at the scene together and whatever. Why must you prove that when they went to the scene they phoned each other?
Yes.
I mean, it's the lowest mark and remark that can be made by a prosecutor in these circumstances.
Yes.
Well, the challenge is that they looked at American authorities, isn't it?
Probably that's probably the misnomer comes from there.
Yes. I mean, I suppose if you are dealing with a hidden enterprise, a drug cartel, and you're trying to break it, then maybe you can try and trap people using cell phone records. But what you are dealing with is a lawful unit, which is committing the crime of racketeering, but it's using the state resources.
Yes.
So, as you say, rhetorically, how do they get to the crime scene if they didn't communicate?
Yes.
Yes.
And there are 7, 10 police vehicles in one scene. Now you must go and check how they call themselves each other for them to be in that scene. Yeah. It is pretty porous.
But they also say so themselves. I mean, if you look at the killing of Mr. Magojela and Demand, Major General Boyson says, I got a call from an informer, and then I called Mr. Olivier. So what's there to be...
And he was updating them as to say he's now from Free State is entering KZN and all sort of things.
Yes.
Now why must you prove that indeed he called him?
Well, why should you then go and obtain
a cellular phone to prove that indeed he called him?
When somebody says, I admit that I called him.
Yes.
Yeah. Then it says, this could have shown not only how they communicated at strategic times before, during, or after the incidents, but also their communication with Boyson. I mean, it's unclear what this is about, because we've just spoken about one incident where Major General Boyson himself admits that he is the one who did the communication and puts all of them in the chain of communication.
Now, how does Mr. Boyson get into a scene after the shooting?
Yes.
If he would not have gone there because he has been called. Now you must prove that Mossad called General Boyson to come to the scene.
Yes, and we've also got evidence here in relation to the death of Nkosi Zondi, where Major General Boyson admits that he was the head of that investigation.
Indeed.
Having been asked by Mr. Ngidi,
yes,
as the provincial commissioner,
yes,
to respond to a concern raised by President Zuma,
yes,
who had a blood relationship with Nkosi Zondi.
yes.
So it's unclear why they're asking for communication when the record is full of the communication.
No, in this instance, Chair, you don't need communication because people are there, they're at work, they are busy working, they're together. Why do you need to prove that they're at work and they're working together?
Yes. Then,
But also on the same point, isn't it that Mr. Danika's testified that every member had Major General Boyson's number and they would call him, and Major General Boyson's instruction was call me any time, and if you mess up, I'll come and clean it up, but just make sure that you call me as soon as possible. That is proof enough that there was communication between all the members, no matter how junior they are with Major General Boyson.
Yes, Chair. But it's like asking me as a DPP, and you say it must be investigated that I communicate with my fellow prosecutors in the office.
look, I mean, I suppose the difference is this: there is that communication which you would expect. The question is whether this is the communication for the purposes of the enterprise. You see, because the enterprise, in a sense, is a deeper enterprise because it's an enterprise that's using the lawful resources of the state. So the whole language, well, let's go and kill a person because they are sought in relation to killing of Nkosi Zondi.
I understand, Chair, but my point being, if people are colleagues, they are working together, why do you have to prove that they are communicating?
Yes. Yes, no, I think it's obvious that they have communicated. That's why they're all there, and that's why there is a person with a gun,
Yes.
and thereafter the gun disappears, and thereafter the cartridges are found. It's clear that they are communicating.
My point exactly.
Yeah. Then the next criticism at 215 is a racketeering investigation of an ongoing criminal enterprise must determine the size and composition of the group involved, its associates, its past acts, intended criminal goals, and its capacity for harm. There was no investigation into the size and composition of the group that constituted the criminal enterprise, but simply a focus on individual participants engaging in specific criminal acts. What do you say about
It's a
this?
blatant lie. On the evidence, as we're sitting here, that statement alone, you can see it's a misrepresentation.
Yes. I mean, we heard from Mr. Mayema, who made it clear that they spent a long time trying to figure out the scope and size.
And the description of the enterprise is there in the indictment.
Yes.
So for a fellow prosecutor to come up with this kind of statement is very, very unfair and unfortunate.
Yes. Then they say, as a result, the investigation is unable to provide a proper analysis of exactly how many cases this group investigated over a period of 4 years, its outcomes, and why there was a focus on 23 dockets, 9 in 2008, 7 in 2009, 3 in 2010, and 2 in 2000, of which 4 dockets were registered in 2011. So they say, well, you can't explain this. I mean, what do you say to that?
What is it that must be explained? Because if you have got hundreds of dockets and where you are able to prove your case is 23, what's wrong with that? So because there are 100 dockets, you must just prosecute all of them.
Yes.
It can't be. It doesn't work that way.
Yes, but I mean, is it not factually inaccurate that there was no explanation? Because in this inquiry, we had Mr. Mayema, who provided an explanation how they whittled down the dockets from 52 to ultimately 23. But at the same time, they didn't abandon the remainder. They still asked Captain Mangena to continue working on them.
Yes.
And as a consequence, Captain Mangena had 10 more dockets than those that were in the indictment.
Yes. Which ultimately, if the prosecution would have proceeded, the indictment would have been amended to include those other instances.
Yes. And they say, if the reason for the existence of the criminal enterprise was to obtain monetary gain or profits through racketeering activities, the decline in the racketeering activities is peculiar. Now, that's because their view is that these activities were at their zenith in 2008 and declined by 2011, starting at 9, ultimately being 4 in 2011.
But that is irrelevant. It's highly irrelevant.
Yeah.
Whether it has stopped or it was still continuing or it was subsiding, it's neither here nor there.
Yes. Yes. It's unclear why there is a complaint that there are fewer acts in 2011, because it could also be an assessment of the evidence that we can only prove 2 in 2011.
Of course.
Yes. But they're talking about this thing about the monetary gain. They say, well, if the purpose of the enterprise is monetary gain, why are they no longer trying to get money in 2011? I think that's what they're asking.
Which will be unfortunate because instead of accepting that people had enough of killing others, they decided now we are no longer going to kill. Why do you want to make a meal out of that they should not have stopped killing, they should have continued killing? Because that's what that sentence, that's what it's suggesting.
Yes, I mean, the decline in the racketeering activities is peculiar. Well, I'm not sure what this means because there could be a decline in the activity or there could simply be no decline in the activity, but your own judgment is that there are only 2 that are prosecutable. And that's why Captain Mangena was continuing to investigate.
Indeed.
And that number could have gone up.
Indeed, sir.
Yes.
Sorry, but then let's say there were no dockets registered in 2011, then which would maybe translate into the activities of the enterprise having stopped. What would be the effect of that? Would it mean that you stop investigating and you close your books and go home because now they've stopped killing people?
The essence of what is being conveyed here, that's what it means, and which I'm saying is untenable. It's very unfortunate that you're saying offenses have been committed because they are no longer committing the offense, they've stopped. Then you can't prosecute them for the offenses that they've committed. In essence, that is what it means.
Then it says a criminal enterprise does not necessarily end when one or more of the participants are prosecuted, since they are motivated by the monetary gain or profits. This I found one of the most bizarre statements.
The lesser said about that statement, the better.
Yes. Because once you prosecute one of the gang members, the natural tendency is for the enterprise to decline because it's finally been broken.
It's very unfortunate.
Yes. Then it says the failure to properly investigate the size and composition of the group involved and its associate explains the lack of charges against the Stenga Taxi Association that allegedly entered into a corrupt relationship with the members of the SVC Durban Organized Crime. Now, you know, many years ago, Mr. Jackie Selebi was charged by the NPA, and there was an outcry about why the people that corrupted him were not charged.
Yes.
And the NPA said to the public, well, we have to stop corruption inside the government first.
That is what was out there in the public, that in order to stop the corruptors, you need to get they call it the big fish.
Yes.
Yes.
But this reminded me of that incident, that the NPA decided it has to stop corruption within the police.
Yes.
And now it's being criticized for not charging the members of Stenga Taxi Association.
And you need to ask, charging them for what?
Yes, well, they say because they entered into a corrupt relationship with the police, they were collecting the bags of money and paying the police, which is corruption under Preka.
But for you to be able to prove that they gave the money, you need them to testify that they gave the money. Now, if you charge them, how are you going to prove that money was given?
And they were your witnesses. Well, they were the state's witnesses.
Yes.
Yes. Yes, I see your point. Yes.
I beg your pardon on that point, but if you charge them and you subsequently decide to utilize Section 204 and use them as witnesses to prove the very point that you are making, that is still possible. So you can still charge them.
Yes. What happens with those kind of witnesses, Chair, it's once it takes the witness stand, you inform the court that this witness is going to testify about incident which, if the court is not satisfied, they might be prosecuted for that. Because for a person to say, I gave the money to the police to go and kill my rival, that is an offense in itself. So in all instances of these witnesses, when they were supposed to testify, that precaution will always have to be taken by the prosecution.
Yes, but I'm saying that, as you answered counsel, you can still charge them.
Yes.
And use them as the Section 204 witness.
Yes.
To prove the very point.
Indeed, Chair.
Correct.
Correct, Chair.
Yes. So in other words, there was no decision not to charge them. The options were open.
Yes, the options are open. If you charge them now or you make them witnesses, depending on what they testify, you'll take it from there.
You know,
It's a strategic assessment and whatever that the prosecution team, as I understand, they will be making.
I understand. You know, the odd thing about this is that if you look at the two critical witnesses that came from Stenga, Mr. Ndlondlo and Mr. Matonzi, they were actually murdered as soon as it leaked that they were witnesses.
Yes.
You know, and then when there is a reference elsewhere in the report about the fact that they were killed. You know, and in the context of the hearsay, we looked at that earlier today.
Yes.
And then now there is the whole thing where you should have charged them, but they were killed.
Of course, they were not fortunate like Danikas who could go.
Who could escape.
Who could escape.
Yes, they lived amongst the black people of KZN.
Yeah. The fear of Danikas is real.
Yes.
Because you have got instances where those who have been identified as witnesses have actually been killed. And the reasoning of the prosecution team, as Mayema indicated, not to identify Danikas as a witness, it comes from that particular kind of a scenario.
Yes. And
Sorry, Advocate Chauke, you, during these investigations, you were the coordinator of the prosecuting team.
Yes.
Can you explain to us, because there is a repeated statement that the investigating team failed to properly investigate the size and composition of the group involved, and its associates. So, which then explains that you could not charge other people, for example, the Stenga Taxi Association or what. Is it true that you failed, or the prosecution team failed to properly investigate the size of and the composition of the group?
From the prosecution team's report and from how I see them having dealt with the matter, it's unfair to say that they did not properly consider this. And even when you would have had Advocate Mayema's testimony, he indicated the process that they have undertaken and to the lengths for them to be able to satisfy themselves that this is the way to go.
yes, but the question is whether they investigated the size of the enterprise. I mean,
Yes, that's why they were able to identify.
Yes, yeah.
The reason why they were able to identify who's supposed to be charged in terms of poker, who's supposed to be the predicate of it, is because you do the investigation and decide who's in, who's out.
Yes.
Yes.
And that is called size.
Yes.
Yes. Then 216, investigations of this nature ordinarily employ informants and confidential sources, financial investigations, monitoring of electronic communication, and Section 252A operations, especially if the allegation is that the criminal enterprise can be hired to kill for monetary benefits. It appears that none of these investigative techniques was employed and would explain why there are no money laundering charges. So they say there are certain techniques that are generally used, but they have not been used, and you didn't charge them for money laundering.
But it's irrelevant. And the facts of this particular case, all that appears in that paragraph is irrelevant.
And 217, it appears that during the arrests of the accused, searches and seizures of their homes were conducted. There is no indication that there were any searches, seizures at the offices of the accused, in particular to search for documents, operational plans, meeting minutes, and any other relevant information on their computers. It appears that the police seized several items when they arrested the accused at their homes, such as computer disks, printers, cellular phones. It is not clear if the items were investigated, and if indeed, to what are the outcomes.
The drafter of this paragraph did not read the dockets and the like. There's no. When was the searches and seizures done? I mean, we're saying here we've got the record here. Where do you find that the Katomania investigators were searched? So that is written by somebody who obviously would not have read the actual matrix of the case.
Yes.
And the dockets.
But it's also unclear what is the relevance. Why would you, when you've got all of these dockets, why would you then go and do a search and seizure in the office?
Searching what? Because the firearms that they were using them is the state firearms, and they have them officially. So we're going to search for what? That the money that he would have been paid, you're going to get it in his house.
Yes.
And then there is the money laundering things, and then cellular phones, and they're like, what is the relevance of that? It's irrelevant.
But why would you charge them for money laundering? You've got racketeering, that's the charge you've decided to press, and you've got the alternatives, which are the predicate offenses.
But we have got no evidence of money laundering.
Yes.
Why must we charge people for money laundering when you don't have evidence of money laundering?
Yes, quite. And then there are also 3 paragraphs that deal with the predicates. The first one, it says there is a lack of objective eyewitness accounts of incidents. The prosecution team places reliance on statements made by the persons charged. It appears that the police and or ICD made very little attempt to find witnesses that saw the incidents happen. What do you say to this? Is this actually factually true?
It's not true.
Yes.
The drafter of that paragraph did not read the statements and the evidence.
Yes. I mean,
You can't charge the accused because of what the accused says.
Yes.
Yeah? I mean, it's just, I'm sitting here as a prosecutor, and it's a prosecutor who wrote this statement. I get embarrassed myself.
Yes. Well, I mean, we went through this. There are just so many eyewitness accounts. It's truly astonishing that they would say something like this.
Indeed.
Yes. And then 219, in all of these dockets, no identification parades were held. Why would you do an identification parade?
A person says, I was there, I'm the shooter. Why must he be identified?
Yes. In counts 3 to 7, the girlfriend of the deceased alleged that she was assaulted by a white male. The absurdity now is that all of the accused, Mostert, Naidu, Makanya, Obach, and Eva, are charged with the assault of her, whilst Eva was not even in the house. So somebody says, I was assaulted by a white man. You can't work out who it is, so you charge 3 white men. Then they say, well, that's a problem.
Well, unfortunately, that is unfortunate as well.
And in Melmoth, 2 witnesses alleged that they were assaulted by the police. They were only taken to a doctor for a medical report in 2012, which means that the report would be of no value in a trial. No identification parades were held, and all the accused were also charged for the assault of the witnesses, despite the fact that there is evidence that more than 30 officers were on the scene. So what's
what?
the problem?
What is the problem? That you charge 23, you did not charge 30. What is the problem?
Yes. Now, you would be pleased to know that this is all of the qualitative analysis of this report. That's what it ultimately boils down to.
Yes. I like I indicated, Chair, it's at the time when it came out and I was served with a copy when I requested it then from Advocate Chauke. These are some of the things that I spoke to him about.
Yes, and this is all that Advocate Batoyi read and relied upon.
Indeed.
Yes. Would you describe this work as actually shoddy and embarrassing?
I wouldn't say so, but I hear you, Chair.
Yes, all right. Thank you. Madam Chair, I took a lot longer on this report, which I thought was going to be a short journey. I've now exhausted all of my time. But I still need to deal with these documents of Mdluli. So I wonder whether there is still any energy left for tonight. And I asked Mr. Mutlamunyan, who already was keen to break more than an hour ago.
Don't worry about Mr. Mushamuyane, Council. I thought that you'll take these points to be a logical conclusion and look at the recommendation, at least for completion of the exercise that you
Yes,
have
indeed.
embarked upon.
Yes. No, thank you, Madam Chair. Let me take the invitation. Thank you. Yes. Do you have page 95 of the report, section F, under the heading recommendations?
I do, Chair.
Yes. Now, it says the following recommendations are made. The racketeering authorizations issued in terms of Section 2, subsection 4 of POCA by the acting NDPP Advocate Jiba on 14 August 2012 is invalid. Now, was there a need for this declaration to be made because this had already been done by a judge?
Not at all. Not at all. And that's my gripe about this, that you are supposed to review a decision, you are looking at the decision as at 2016 about the case that is decided by Sean Abrahams. Why go back to Jiba if there's no other motive other than what is said to be here?
And then 2, the racketeering authorization issued under Section 2.4 of POCA by Advocate Sean Abrahams on 16 February 2016 is invalid. Now,
how can a prosecutor pronounce that?
yes, that's what I wanted to ask you.
A statement issued is invalid. How is that possible?
Who is entitled under Section 172 of the Constitution to pronounce on the validity of administrative acts?
Is the court.
Yes. Yes. And then
what is happening here, Chair, is this case was this matter was at the review in front of the court. Now, what that statement says, it has usurped the work of the court and substituted itself.
yes, well, there was a review at the time, which was, I
Yes.
think, according to the evidence, scheduled for hearing in May
Yes.
of 2019.
Yes, where Advocate Epstein, SC, was going to argue representing the state.
Yes.
And that is the court that was going to say whether it's valid or invalid.
Yes. And then Advocate Batoy then said, look, I've got my own panel. Just withdraw in court. I'll deal with it internally.
Yes.
But your point is that a declaration of invalidity could not be made by this panel of 4
No,
or panel of 2.
no. Not even the NDPP herself.
Yes, because her powers are confined to Section 179.
Yes.
The prosecution instituted against all the accused on the racketeering charges based on the authorizations issued by the acting NDPP and Jiba and the NDPP S. Abrams, as set out above, should be withdrawn.
Again, Chair, ask yourself what is the relevance of acting NDPP Jiba there, when in fact the case that was on the roll, which was being considered there, was the one authorized by Abrahams. And as in 2019, Jiba's things had fallen by the wayside in 2014 already. Yes. I think it was 5 years. It was 5 years thereafter. Now you must ask yourself what is this appetite of Jiba there.
Yes. But I mean to say...
Sorry, of Advocate Jiba.
Yes, but to say that all of the charges against all of the accused without analyzing the case against each of the accused. I mean, you have this thing about Mr. Paul Mostert, who has 13 murder charges.
No, the qualification of that is the second paragraph, Chair, that they say the Director of Public Prosecution, KwaZulu-Natal, should, in compliance with the prosecution policy, review the evidence in respect of the remaining charges preferred against the accused and decide whether or not to prosecute, not to prosecute the prosecution against the individual accused named in those charges.
I understand that, but I'm talking about racketeering, which requires the existence of predicate offenses. I'm saying as part and parcel of racketeering charges against Mr. Mostert are 13 murder charges, which are predicate charges.
Yes.
And then you make a blanket statement like paragraph 3 that everything against everyone must be withdrawn without any analysis of the case against each individual.
Very unfortunate.
Yes. And then the DPP, which is the point you were making, of KwaZulu-Natal. Now, we spoke with another witness about the DPP. I just want to know if you had any knowledge about the allegations of a conflict of interest relating to her.
I came to know them long after these decisions were made, that I came to know that she was somehow married to one of the police officers of Katomani or organized crime in KZN. I was not aware.
Yes, but we also know now that she was the prosecutor assigned, specifically in the case of Mr. Mhlongo.
Yes, from what Mr. Mhlongo testified, yes.
Yes, and that case actually also emanates from the same set of facts as we are dealing with here.
Indeed.
Yes. And there she was criticized for making a false insertion on an affidavit by a judge.
Yes.
Yes. And were you aware of any disclosures that were made by her in relation to exercising the authority to withdraw these charges?
No.
Yes. Well, we also know that she is the person that had a conversation with the National Director of Public Prosecutions while she was giving evidence in cross-examination.
I believe so. That's what Advocate Shamela Bato indicated to the panel, that she had spoken with the DPP of KZN, because after Advocate Noko was transferred to DPP Northwest, she became the acting DPP of KZN, replacing Noko.
So she is the person who must now review the evidence in respect of the remaining charges preferred against the accused and decide whether or not to proceed with the prosecution against the individual accused named in those charges. Now, that relates now to the individual offenses. And we know here that except for the KwaZulu case, everything else was withdrawn.
Yes.
Including the 13 murder charges against Mr. Mostert.
Yes.
And then a copy of the memorandum will be provided to the DPP in KZN.
The effect of this withdrawal means that none of the victims concerned have had any closure.
Indeed, Chair, that's how I understand it from where I'm sitting.
In your own words, what does it say about the role of the NPA?
The NPA failed the victims and the people of South Africa at large in respect of this specific matter.
But would you say that that should not really be the end of the matter, because withdrawal does not necessarily mean that such charges cannot be reinstated?
Indeed, from where I'm sitting, all the charges, they are capable of being reinstated, because there's not even one where the accused have pleaded except the quasi end of case. Even in that one, legally, I think once one can justify send it on a specific kind of review proceedings, one should be in a position to get a declaration. Yeah.
Yes, if a proper analysis of the docket is done,
Yes.
and a finding is made that there was indeed evidence justifying the prosecution.
Indeed, Chair.
Thank you, Madam Chair.
Are you still on the report?
No, I'm not on the report.
I'll just want to touch one or two things on the report. Yes, It is noticed from recommendation number 4 that the recommendation is that the matter be referred back to the public prosecutor, the Director of Public Prosecutions, KZN. That's the recommendation of the authors of the report, right? But then I'd like to, well, I don't think we have this before us, but it's part of this statement of Advocate Batohi. In particular, when one looks at SB4, page 449. Is it 449? Man, 229, I beg your pardon. The hour is very late. I beg your pardon. Yeah, and actually paragraph 4 on page SB 230. Now that is the letter written by Advocate Batohi to the KZN Director of Public Prosecutions. Now,
I have it, Chair.
yes, and in paragraph 4, in the middle of that paragraph, do you see that sentence that you are accordingly requested to evaluate?
Yeah, you are accordingly requested to evaluate the evidence in each docket and decide whether to prosecute the individuals who may be implicated in those matters. I bring to your attention that the panel also found that there is insufficient evidence against General Boysen in respect of the other charges preferred against him.
Thank you. Stop there. Now, are you able to comment about this extra comment that is made by Advocate Batohi, that she would like to bring it to your attention that the panel has also found that there is no sufficient or there is insufficient evidence about General Boysen? I'm asking this based on the comparison between the recommendations that are done. They appear to be covering everyone, that the DPP KwaZulu-Natal should look at each and every docket. It does not point out to a different approach in respect of Advocate, in respect of General Boysen. But then Advocate Batohi has deemed it necessary or maybe important to also bring it that rider to the fact that look at the dockets, but there are no findings against Boysen. What do you make of that statement?
The metaphysics of it all is that Advocate Shamila Batohi has gone all out to protect and decide that General Boysen, in particular, should not face prosecution in respect of these cases.
Thank you.
Let me follow up on that point. But I think in fairness to Advocate Batohi, at least she makes a request to Advocate Harrison, requesting here to evaluate the evidence in each docket.
Indeed, Chair.
At least that you should give her the benefit.
I
At least,
do.
Yes, that at least she left it in the hands of Advocate Harrison to do what she requested her to do.
The unfortunate part is why single out General Boysen, as opposed to say in respect of all the accused, there is insufficient evidence. Why specifically it should only relate to General Boysen? That's the comment I was trying to put across.
But it was for Advocate Harrison to use her discretion
Indeed.
in the evaluation process
Indeed.
to determine whether she should find that there was insufficient evidence against General Boysen.
Yes.
Yes.
She's being informed that there is insufficient evidence against General
Yes.
Boysen.
Yes, thank you.
Thank you, Madam Chair. I am looking for a section in this report. I think I've looked for it before, but it's now escaped me, whether there is anything in the report that analyzes the predicate offences against Major General Boyson that would justify the second part of that paragraph, that there is insufficient evidence against Major General Boyson.
No, the exercise that we did share was had gone through the cases to say there is no evidence, where we analyzed to say it was superficial analysis of the evidence in respect of those predicate offences.
Yes, no, looking at, you see, she puts a sentence. Let me just open the letter from the NDPP. It's from the NDPP. So we just looked at now. Yes. Now, the paragraph you were referred to by Madam Ramachaka, SB 4230,
Yes.
says, I bring to your attention that the panel also found that there is insufficient evidence against General Boyson in respect of the other charges preferred against him. Remember, there were five of those charges, or seven, 2 murder charges, firearms control charges, and so there are 5 predicate and 2 racketeering.
Yes.
So 2 murder, 2 of firearms control, and 1 for defeating the ends of justice.
Yes.
This report has not analyzed a single one of those charges against Major General Boyson.
Not that I can remember now. From the exercise that we have done,
Yes.
no, there is.
Yes.
Yes.
And I couldn't remember if there is a specific sentence in the report that even says, we've looked at the predicate offences against Major General Boyson. Our view is that there is insufficient evidence to charge him with them.
It might have escaped us, the chair, but from the report as we have gone through it, I don't remember where we specifically make reference to General Boyson as an individual as opposed to all the accused.
Yes, I mean, as a matter of fact, there is no analysis of the predicate offences.
Yes.
You know, and that's where it does strike one as odd that the NDPP would go out of her way to say, look, racketeering scratch for everyone, but this one of the predicate offences scratch only for Major General Boyson, in your discretion. But, I mean, just on that issue, you know, the chair says, listen, this person is being asked, exercise your discretion, right? But how does that actually work when you are told by the NDPP that exercise your discretion, but I'm telling you there's insufficient evidence?
Proceed with caution.
Yes. But what's the point of doing that? What's the point of saying to someone there is insufficient evidence if you genuinely want them to exercise their discretion?
This is my view as the NDPP, but you can use your discretion, but understand this is my view.
But are you not trying to, this is the point I'm making, are you not trying to influence them towards your view?
Indeed, Chair. That's why I'm saying you are being told proceed with caution because already I've considered the merits as the NDPP.
Yes. Thank you.
What about their independence? The NPA in the Constitution tells them you are independent, you act without fear, favor, or prejudice.
Yes, indeed, Chair.
And this is a senior prosecutor. I'm just looking at it from that angle, that Advocate Harrison is not a very junior prosecutor.
Of course.
And we have been told by Advocate Batoyi many times in her evidence, she actually rehashed the Constitution and the NPA Act in relation to this very point of independence. Now, she's requested to do something, and she says, take note. Now, an independent prosecutor who acts without fear, favor or prejudice, will do her work,
I've got no doubt. I think
irrespective of what the boss tells her what to do.
I've got no doubt. I think that's what Advocate Harrison would have done.
Yes.
Yes.
So, Council, I'm saying, I note what you say, but when we look at the prescripts of the provision of the Constitution and the Act itself, the buck stops with Advocate Harrison.
Indeed. That's why I'm saying I've got no doubt that she would have done that independent of the influence that or otherwise that the NDPP would have set.
Yes, thank you.
Madam Chair, I don't think we can proceed further for tonight. If I can ask for an adjournment, I'll probably need an hour. Okay, I've been promising an hour. So I'll need, but I'll need the 9 to tea time on Monday to wrap up what I still need to cover with this witness.
That will be 2 hours.
9 to 11, yes. Oh, that's still 2 hours.
That will be 2 hours.
Okay. So, I'll need, yes, an hour, 9 to 10.
Will that be also in respect of the outstanding witnesses you'd like to call? You remember you mentioned,
yes.
I'm sorry, Advocate Chauke, you mentioned whether 3 to 4 witnesses that you said may be short?
Yes, there are in total 4 witnesses that I've consulted with, but we will probably call one. There is General Mabula, we will most likely call. There is Advocate Dion Barnett. He has recently made contact, and we have to decide whether to put in a statement or not. There is Mr. Ngasana. We've finalized his statement. It's a question of him signing on it. And there's Advocate Sean Abrahams. And again, it's not strictly speaking to call him, but we have to decide whether or not to put a statement. So out of those 4, it is Mr. General Mabula that I wish to call to give oral testimony. But it's on a single issue.
In respect of all of them?
In respect of the 4, the person I am sure I will be calling is General Mabula. I might want to call Mr. Dion Barnett because he is on a different issue, on the Mdluli issue. General Mabula is still on the Ketomano issue.
Yes. We have given you a schedule that we will be available until Tuesday.
Yes. I'll make sure to fit in.
Yes, if you can try that so that we don't take from the time that we seek to allocate to the evidence leaders.
Yes, thank you. Understood.
Advocate Chauke, we adjourn now until Monday at 9 o'clock, and you will continue. You remain under oath.
Thank you, Chair. I note.
Thanks to your counsel and to all of you for your patience. We will pause here until 9 o'clock on Monday. And if there are any statements, please, those statements must be circulated timelessly so that we don't adjourn again. And remember, once we adjourn on Tuesday, we will start with the evidence leaders early April. Thank you. We adjourn.